off and do 4 bills
All
that
right,
I have.
you're about to be live. You're about to be live. So just hold tight, please. We are live.
All right, good afternoon, everyone. Welcome to day 2 of our 3-day hearings on 15 bills relating to police reform. Today we have Senator Sidnor, and I'll be presenting 4 bills today, and then we'll followed by expert panel and then public comment and testimony. So same format as yesterday. Senator Sidnor and myself will present. We'll go first, and then the experts will go present, and then we'll open it up to the public. After the 2 senators present, we'll have time for Q&A, questions from the panel. Senator West, I'm ready for your best today, and then we'll go on to the public comment, and that'll conclude the proceedings for today, for day 2. Do you want to mention that Senator Castley had a trial, so he is unable to participate. He'll be in and out, maybe. We have Senator Huff, who's working his day job on Capitol Hill, so he'll be in and out as his availability allows him to do so. And then we have Senator Lee and Senator Carter have other legislative duties and responsibilities for the Legislative Policy Committee, which is going to be convening in about an hour and a half. So they'll be back and forth and attending to those responsibilities as well. So just for the public, know that everyone is locked in and focused on this issue, but that other professional and legislative duties have called them to attend to those things as well. So just a little bit of background there. So with that, we'll start off. I'm going to go ahead and present for JPR 10, JPR 11, and JPR 13 and 12. I'll start off with JPR 10, and then we'll switch over to Senator Sidnor, and you can present your bills. So with that, I'll just jump right into it. So JPR 10, and I think the best way, this is a little bit of it's a new issue, and it's a little bit longer of a bill. So I'm going to walk through the bill with you guys. And so for Senator West, I know we had a conversation. If you want to kind of follow along with me, note on for questions you have, and I'll be able to respond when we finish. So the bill really starts on page 11. This is, again, JPR 10. This is state prosecutor investigation of crimes. It's independent investigations. In Maryland, we have 24 jurisdictions, and currently only 2 have independent investigations in areas of serious police misconduct or serious physical injury and death resulting from the use of force by a police officer. And that's Montgomery County and that's Howard County. They have an MOU. So if something happens in Montgomery County, the state's attorneys from Howard County investigate and vice versa. What this does is it lays a framework for that independence statewide, and the responsibility would be nested under the Office of State Prosecutor. So I'm going to walk through kind of the structure, the responsibilities, and then address some of the concerns that the state's attorneys have expressed in their testimony that they submitted, and then I suspect that they'll tease out in their testimony later on today. So start on page 11. It applies only to a criminal offense involving serious physical injury or death resulting from the use of physical force by a police officer, and any criminal offense committed by a police officer while in the performance of the police officer's official duties if the state's attorney with jurisdiction, so where the offense happened, requests that the Office of State Prosecutor go ahead and take those responsibilities, or the Attorney General, if the Attorney General requests that. The next major piece is on the bottom of page 12. So with regard to the investigation involving the alleged criminal offense described, the state prosecutor must coordinate with the state's attorneys to figure out if there are any conflicts of interest. Again, this is a part of the transparency and independence in investigation. So that's the first step, to find if there are potential conflicts of interest that could affect the impartiality of the investigations. Skipping to then page 13, we'll start at the very top. And this is, again, I think a point of contention, and I think I'll try to clarify it before the state's attorneys get on later. But to determine if the state prosecutor, the state prosecutor here will have the sole discretion notwithstanding the objection of the state's attorney, whether the state's prosecutor or the state's attorney will be responsible for the investigation. So in this point, the Office of State Prosecutor can say, look, we want to do the investigation, even over the objection of the local state's attorney. Now, the state's attorneys have submitted testimony saying they have a constitutional responsibility to prosecute crimes that happen within their jurisdiction. Now, I think the distinction here is that this only addresses the investigation. It still leaves the initial right of refusal, if you will, to the state's attorney. So the state's attorney still has the ability to prosecute anything that happens within their jurisdiction. This only pertains to the investigation. And so I think that there's a little point of clarity there that I know that the folks behind me will address from the Office of State Prosecutor, but then I'm sure the state's attorneys will bring this up as well. But I wanted to highlight that for folks up front. So if the state prosecutor elects to investigate, they will then assign investigators. Now, the investigators are going to be, if you read a little bit farther on, they shall be a police officer currently employed in a law enforcement agency around the state, so one of the 24 jurisdictions. Their salary and their time will be paid out of the Office of State Prosecutor. So the local jurisdiction will not incur any cost for that. The Office of State Prosecutor will also be responsible for staffing that investigation and helping that investigator. Now, if you go farther down, I had a lot of conversations over the summer, and it talks basically addressing issues of diversity, because if you have an independent unit investigating things in, let's say, different parts of the state, you want there to be close attention paid to the diversity, geographic diversity, ethnic, racial diversity. So the next several lines begin to address making sure that this is a diverse team, and that every effort is made to make sure that the staff from this agency is diverse. So the state prosecutor shall hold at least one event annually at each of the HBCUs and universities to recruit investigative staff. We're still toying around with this language. I think that we definitely need to incorporate law schools. We don't have any historically Black law schools in Maryland, but regionally we do, obviously. Howard's right down the street. So I want to make sure that also they're going out and recruiting, folks that are professional staff, Black attorneys as well. So I know that there are several concerns that have been raised over the summer. So we're working on some of that language to develop that idea a little further. Again, the concept here is that the investigators will be kind of on loan from those jurisdictions. So if you have an event, and it could be within the jurisdiction that the event occurred in. So if you had something happen in Montgomery County, the officer could be from Montgomery County. They could be from Howard County. They could be from Hartford County. So, and so on. Moving on to page 14. Now, this is already in the statute, but the state prosecutor shall make confidential report of the findings of any of the investigations. That leads back to that struggle over the investigation and prosecution. The Office of State Prosecutor already does this for public corruption cases. So they already do the investigations and then hand it over to the prosecutor or the attorney general. They do this already on a number of cases that fall under their purview, which are listed earlier on in the statute. So this is something that they're accustomed to doing. It's not new. So I just wanted to highlight that again for folks. Again, farther down on page 14, it just talks about the public piece. So the product of those investigations will be made publicly available on a website. So the prosecutor shall place a report of the state prosecutor's investigative findings and recommendations for prosecution or not on the public website. So that's another element of transparency that I think will be critical for restoring trust in these types of investigations moving forward. Again, on page 15, going towards best practices and ensuring that there's a watchful eye on this process. This legislation calls for the establishment of a police criminal misconduct policy board. And you can see the composition of that board on page 15. So the state prosecutor is going to be a part of that, the attorney general or their designee, secretary of state police, and so on, public defender, and so on. Now, the responsibilities of this board will be to develop and publish best practices and policing related to the investigation of criminal offenses committed by police officers in the course of their official duties. Talks about the state prosecutor, the state's attorneys, law enforcement officers. So there's a set of experts that are going to be keeping a watchful eye and developing best practices on a continual basis. That can be found on page 17 and page 18 of the bill. It also speaks to the selection of the investigators and ensuring that there's a diversity there, and the staff assigned to the investigations that perform the work relating to the investigation. So there's some best practices with not only the hiring, the training, the oversight, the practices, procedures. All of that is established and it falls under the purview of this board that will be established under this legislation. And that essentially, that long explanation, that's it. Again, I'll go back to where I started, which was Montgomery County and Howard County have, you heard a little bit of that from Councilmember Juando yesterday, have established a process in which they have somewhat of independence, meaning they're not investigating their own. And so this takes that idea, expands it, puts it under the Office of State Prosecutor. I'll say that the Office of State Prosecutor, the state prosecutor is appointed to a 6-year term. That person is then confirmed by exec noms and the Senate. I think that's actually a positive thing, because you have an element of political accountability in that the governor appoints and that the Senate is involved in the confirmation or the approval. And then they're insulated from the political whims, and there's a certain independence there because they're appointed for a 6-year term. So I think that's an actual strength of this framework, and that's exactly why the Office of State Prosecutor was it's kind of the initial reason for the structure of their office in the first place, was to ensure that there is an air of independence and accountability there, that they're not subject to the whim or the hiring and firing of a governor if let's say there's an investigation there. So I think that's a strength. And so I'll put that bill before the committee for your consideration. I'm happy to take questions after I finish a couple more bills. I see that Senator Huff has already raised his hand. So I'll just move on to continue the hearings to JPR 11. Now this deals with the Maryland Tort Claims Act and the Local Tort Claims Act. Right now, the bill essentially for non-economic damages, it removes those caps. And when we talk about non-economic damages, we're talking about for economic damages, it removes the cap. When we're talking about economic damages, we're talking about medical bills, out-of-pocket expenses, and so on. And the reason for that is that a lot of times when there's a serious injury that occurs, the medical bills will far exceed that $400,000 cap that's currently within the law. And that's just simply not enough. And so it removes the cap for the economic damages. And then for the non-economic damages, it creates an escalator clause. So for the Maryland Tort Claims Act, it goes up $15,000 every year, every October under the bill. That's on page 24 of the bill. So it's for individual claims, it goes up $15,000 every year. And for tort claims that arise from the same occurrence, by $30,000 every year. And that's for the Local Tort Claims Act. And for the Maryland Tort Claims Act, which is then on page 25 and 26, it bumps it up $15,000 every year. So just bringing it back, just to make it easier to explain, you have non-economic damages, economic damages. For the economic damages, it removes the cap. For the Maryland Tort Claims Act, it provides for an escalator clause. And for the Local Tort Claims Act, it provides for an escalator clause so that every year it goes up. So we don't have to revisit the statute every year. And so again, this will incentivize our state and our local jurisdictions to hold police more accountable. This bill only applies to torts arising that are committed by law enforcement officers. So it's limited in scope in that respect. And that's the general scheme. So I know there will probably be some questions on that. Moving on to JPR 13. JPR 13 just says that it's pretty straightforward. I think it's a one-page bill. It just says that the commission may not recertify an officer without a psychological evaluation. Now, typically what happens is you're initially certified as a law enforcement officer. You have a psychological evaluation. Your certification lapses every 3 years. Under the current law, you're not required to get another psychological evaluation at the end of that 3 years when you're re-upping, so to speak. This just makes that requirement for every time you recertify, for whatever reason, you're coming back into the service or the time has just lapsed. It just means that you have to have a psychological evaluation. Now, I understand that that leaves a gap in that it doesn't cover things that if you have some sort of a severe, if you're involved in a shooting, for instance, or some sort of a traumatic event, it doesn't mandate that you have to have a psychological evaluation right after that event, for instance. So it is limited in that respect, but I think this bill opens the door to that conversation, and happy to have the feedback there. Finally, for JPR 12, that requires a law enforcement officer to be subjected to drug and alcohol testing after the following events occur. And that's on page 31. If the officer engages in conduct that results in the death of another or serious bodily injury to another, or they discharge a firearm. Now, that doesn't include if you discharge a firearm as part of a training exercise, or if you're using ammunition that is not designed to cause death or serious bodily injury. Now, that the results, the test must occur as soon as practicable, and the results must be sent to the head of the law enforcement agency or their designee, the internal affairs investigation of the law enforcement agency, and to the victim of what happened within 5 days, and to obviously the officer within 5 days. Now, I will point out one thing is that you'll notice that at the very beginning of this portion of the statute, it does talk about that if you compel, and if you compel this test, then it's not admissible or discoverable in a criminal proceeding against a law enforcement officer, and that would be the case under the way that the bill is drafted. So that doesn't affect obviously civil proceedings, but for a criminal investigation, if this test is compelled, if you have to do it, then you're kind of excluding it or precluding it from being used in a subsequent criminal investigation. So something for the committee to consider there, and maybe there's a workaround that we can discuss. So with that, I'll conclude and pass it off to Senator Sidnor for the presentation of your bills.
All right, and good afternoon to everyone. I'm here today to present information with regards to JPR 8 and JPR 9. So with JPR 8, it's entitled Public Information, Body Worn Camera Recording. I look at it as a bill, as a body camera presumption of release. So you might ask why why the need for this presumption of release, and I would like to point out two things. One, back when we first started session, this is going back in January, there was an incident that had taken place in Baltimore City on January 17th, 2020. And it was a recording that had come out with an incident where we saw a young man being arrested by Baltimore City's police as he was being kicked and the young man that was where an arrest was being attempted was trying to be pulled from under that officer. There were a number of city officials as well as the governor who came out condemning what they saw on this video. And about 3 days later, Baltimore City Police, they made 3 arrests. What we then found out come 164 days later, WMAR2 had reported some new video. And with that new video came out some truth that a Baltimore City police sergeant was not being forthright in the events that had taken place, and the young men who were arrested, ultimately, they were released, and that Baltimore City sergeant was indicted by a grand jury for making a false statement to police and misconduct in office. Additionally, a colleague and I'll go back to the fall when I was in the House of Delegates, there was a shooting of a gentleman, Jamal Ramon Taylor, in Hunt Valley. My colleague and I, when we wrote to our police chief to try to get some additional information on that case, as well as asking about the release of that particular video, we were asked if we would want to have a meeting instead. At the time, there was an ongoing investigation going on. And we were also told that Baltimore County was in the process of working with its state's attorney to put together a body camera release policy. Anyhow, some months later, this past May, we were finally able to meet with the police chief. And the question was again raised about seeing this particular body camera footage. The response that we got was that that particular video didn't necessarily fall under Baltimore County's policy, which was just introduced in February. So my colleague and I have yet to see that video. Now, mind you, and I will say that there have been other incidents that have occurred in Baltimore County where the police chief and the agency have shared some video footage. But the fact of the matter is there is enough anecdotal evidence which demonstrates that law enforcement, unless required to do so, will withhold this body camera footage as long as or whenever, however they can. In fact, there were just an incident that had happened in Rochester where there was some comments that had come out that the chief and deputy police, because they were concerned with the killing of Daniel Prude, asking that city hold its body camera footage. Again, this bill, what it does, and I mind you, it in looking at it, the language still needs some work. So I'm totally open to working with my colleagues on this. But the idea is that we have a presumption of release and that we allow the citizens to get to the bottom of the footage that they pay for. So with regards to JPR 9, a rebuttable presumption of inadmissibility, and I'm pleased that later on you'll hear from a Georgetown public policy professor, Andrea Headley, who has done research about body cameras and the like. She'll be able to talk from a sociological perspective on this bill. What the idea is with this bill is that we put a lot of resources into providing body cameras to our law enforcement. However, we've had incidents here in the state of Maryland and across this country where law enforcement, they have done things to undermine the use of those body camera footages. It was reported that in San Francisco, police officers were instructed not to use their body-worn cameras during their illegal raid of a journalist's home and office. ABC has also reported that some New York Police Department officers were sending verbal and nonverbal signals to each other when their body cameras are turned on. And this is something that a watchdog agency had found. Here in Maryland, just under about 2 years ago, we had a Baltimore City police officer who was charged with misconduct and fabricating evidence in connection with the 2017 body camera video wherein he didn't activate his camera and was seen placing drugs, with the footage of his camera automatically recording through a feature where the camera had captured 30 seconds of video prior to his activation. So again, the purpose of this is about uncovering the truth, which is impossible when an officer fails to activate their camera or chooses to turn it off prior to an encounter. So with this bill, essentially what it does is it makes this presumption that the officer should have the camera footage on, and unless unless the state can prove that there was a malfunction in the camera, if that evidence is attempted to be introduced, it would be inadmissible. So that's the genesis of it. This language was initially offered in legislation that passed in Colorado earlier this year, and is something new, but it is, again, is something that we believe goes to the whole basis of why we have body cameras on our law enforcement. Anyhow, we're putting it on so that we can be transparent in how our law enforcement is acting with its citizens, and obviously when law enforcement isn't doing what they're supposed to do, it undermines the whole credibility of these programs that many of our local jurisdictions have invested a lot of money in. So with that, I'll rest.
All right, excellent. Thank you, Senator Sidnor. Now we have questions. I saw that Senator Huff's hand went up first, and then we'll move on to Senator West. So Senator Huff, go ahead.
Yeah, a couple questions. So on the first bill we heard,
yep.
I assume the presumption was that we want to have an independent agency investigating these because they're covering up, or they're not being forthcoming with police brutality claims. And if you look at the lawsuit data, most of the claims in the state are a large chunk of them are coming from the city. The city pays a lot of money out in police misconduct claims. So under that scenario, though, you would remove from Marilyn Mosby's office, correct, the ability to investigate these police claims and give them to Baltimore County or another county?
So the way this would work is that the Office of State Prosecutor would have the ability to take control of that process. So it doesn't mean that the local state's attorney couldn't investigate it if the Office of State Prosecutor allowed them to do it. So, but it just gives the Office of State Prosecutor original jurisdiction, if you will, over the investigation. Not jurisdiction, that's the wrong word. It gives them the original domain over that investigation. So again, it's not an absolute. It's just if the Office of State Prosecutor, I'll just read the language, so I'll be precise. On page 13, it says determine. So it's in the state prosecutor's sole discretion, notwithstanding any objection of the state's attorney, whether the state prosecutor or the state's attorney shall be responsible for investigating the offense. So the investigation piece is under the initial, purview of the state Office of State Prosecutor, for lack of a better word. So that piece is yes, maybe. And then what was the second part of the question?
Well, I guess my point overall is I'm trying to understand the point of the bill, because at least my criticism, many of others, the criticism of the state's attorney in Baltimore City is that she's been too quick to prosecute police, and then she's been anti-police. So if you take her out of it, I would actually think you would have less prosecution of police, because she's been, in my opinion, overly zealous in prosecuting police. I mean, we saw that after the Freddie Gray, when the officer, she overcharged. But it just strikes me as ironic that you would remove the Baltimore City state's attorney, who's been overly aggressive, in my opinion, in charging police, under the presumption that somehow we're undercharging police. Your bill's going to have in my opinion, how it will not have the opposite effect of what you want. You're going to have less officers charged, because most of the misconduct claims in the state are in the city of Baltimore. And we all know that state's attorney will charge them at a drop of a hat. So how would you end up with more prosecutions? You'll end up with less if we pass your bill.
I'm not suggesting we'll end up with either. What I'm saying, and first, it's not directed, toward any particular state's attorney. I would say, and that's the one part. Second part is that we can't determine the outcomes. This piece, the question you're asking about, only deals with the investigation. And so you have an independent investigation, and the result of which will be made publicly available. So there's an air of transparency and independence in the investigation. The decision to prosecute is still left with the state's attorneys. And that's one thing, and that was kind of like their major criticism, was that it was infringing on their ability or their responsibility to prosecute. That is not tampered with under this legislation. So it's just the investigation. Yeah. And so that's one thing. And two, I remember what you said earlier, was it doesn't shift it to a specific jurisdiction. This responsibility is nested under the Office of State Prosecutor, who then can enlist the help of investigators who may be from X jurisdiction, Howard County, Baltimore County, wherever. So it doesn't necessarily shift that responsibility to another jurisdiction. The responsibility is nested under the Office of State Prosecutor under this bill. But it doesn't have any effect on the prosecutions. The state's attorney can still prosecute at their will.
I just think it may have the opposite effect of what you want. I mean, or what the purpose of these hearings. In fact, I might be in favor of removing her investigation powers. But on another subject of that bill, why create a new independent agency to create police conduct policies when 3 years ago, when we did the police reform bill, we made the Maryland Police Training Commission independent. We put citizens on there. We put activists on there. We put doctors on there. And the Maryland Police Training Commission is doing these things and coming up with the standards. So are you just going to get rid of the Maryland Police Training Commission? Are they going to be redundant to this new board that you're creating?
No, the board that is under, I think you're talking about the board.
And you and I sit on that. Yeah. We're members of the Maryland Police Training Commission. You and I are.
Yeah, no, I'm aware. The board that's established under this legislation only deals with and I'll read it to you again, so I won't, parse it. She'll develop best practices relating to the investigation. So these are investigations, not necessarily training standards and the like. So the investigation of criminal offenses committed by police officers in the course of their official duties, or the state prosecutors, state attorneys, law enforcement agencies, and the selection of the investigators. So it's the best practices that relate to the responsibilities that we're giving them under the bill. So there's no mission or scope creep with the Police Training and Standards Commission there. It's two separate things, two separate.
So the best practices of policing still rely with the Maryland Police Training Commission.
That's absolutely right.
And yours would only be the prosecution police. Okay. Then on to your next bill dealing with the tort issue.
Yep.
And removing the caps.
Yep.
So there's a lot of towns in Western Maryland where they have their own police force and they have an annual budget of anywhere from $1 to $3 million in total. So if you're one of these small towns, and I happen to know because I live in one that has, a budget of probably annually $3 million or less, and they have a police force, how do you continue to have a police force when yet you are facing at any time unlimited liability? A lot of these towns can't afford $1 million suit against them. That's why we have tort claims for all the acts that these small towns do, from road work to, construction, things that are life and death that they do, public works and everything else, because if they were to have an unlimited claim come against them on anything, it would bankrupt the whole town. So how do you propose this would work for many of the towns that I represent in Frederick and Carroll County, which they have a budget usually less than $5 million?
I think that, obviously it's not outcome determinative, but it will allow for some additional relief for the victims that are essentially, and you're going to hear some, I think, pretty compelling testimony and stories that with the panel behind me, but for the victims that are essentially, a lot of the times their out-of-pocket expenses or their medical expenses will far exceed whatever they're able to recover. It's just, it's such an injustice. And the theory here is that you are going to incentivize those locals, and the state, frankly, under this bill, to pay more attention to the training and the oversight the conduct of their officers. Now, obviously, again, this only applies to an officer that's operating within the scope of their official duties. If there's a gross deviation, then they're personally liable, right? But so your local municipality or your county wouldn't be on the hook there. But that's the theory behind this, and I think that you're going to hear some pretty compelling testimony that right now what we're doing is not working with respect to the victims that are being re-victimized economically and otherwise.
Well, my concern with the bill is this: if you are Montgomery County or the Frederick County Sheriff's Office, you can afford Baltimore City. If you're a large jurisdiction, you can afford it. But if you're a small municipality, you can't. And so what I fear will happen, just by looking at the insurance or liability cost, like in my district, the town of Mount Airy, the city of Brunswick, a lot of my small municipalities, Thurmont, have their own police forces. And those small police forces, quite frankly, are the best. They are community policing. They know the area. They know the residents. They live in the community. Oftentimes, they grew up there. They are the essence and heart of community policing. And if a small town with a budget of $2 million looks at the police force liability insurance or a potential cost of it, I fear they're going to ditch their police force and just get resident troopers from the deputy's office from Frederick County. And then, you just get who they assign you. You lose the mayor, the city council, and these small towns lose control over their police force, and you lose that important community policing function.
No, I think that, you bring up an interesting point. Obviously across the state, there are different insurance mechanisms. So some municipalities will, I don't know of any that go naked without insurance. Some do it themselves, like Baltimore City. Some obviously go out in the market and they get insurance, and that underwriting process takes into account, I don't think, this isn't done enough or to a greater extent as it should, but that underwriting process obviously takes into account some of the standards and the training and so on. So for your locals, I think that the fact that they have a pristine record, that they are engaging community policing, and that they're, are less likely to have had a major incident like this factors into that. And so, I'm unaware
there's bad actors in every area, and there's people that make false claims. And just if you have a false claim or two come forward, the lawyer's going to figure out what it's going to cost to fight it out, what the potential loss is, what the settlement cost. This is going to dramatically increase the cost. So I'll just move on to my last question, which was, we looked at under the last one, I remember Catherine Pugh was a big proponent of doing the psychological testing when she was chairing the task force iteration of this a couple years ago. And we ended up not going forward with it because the Psychological Association, and there were HIPAA laws, there was all kinds of privacy laws that we ran into that we couldn't do that. And we were discouraged from doing that it was violating their privacy laws. So how is this not running into HIPAA?
So that goes to the limited nature of the bill. So this only goes to the certification or the recertification of the officer. So you go through it once when you're initially certified. Right now, you're not required to do it if you're recertified every 3 years or for whatever reason that you lapsed. Maybe you go out of service and come back into service. The way that this bill is drafted, it only requires you to go through that evaluation when you are going through the certification process, which you would have had to have done 3 years prior anyway. So those concerns are probably not valid under the way that the bill is currently drafted. I think that, the way that if you want to go farther the other way and say that this person should have a psychological evaluation every year or every 6 months or after a significant traumatic event, that's when you'll get into some of the problems that arose a few years ago when we were evaluating this issue, along with the cost. So the limited scope of the bill leaves a little bit to be desired in terms of those that want more consistent evaluation, but I don't think really raises the concerns that I don't think it touches the concerns that you're raising today.
Okay, and just last question on the blood and alcohol testing. I assume it's not admissible because if you're forcing it to do it, you're violating their 8th Amendment right. Is that what it is?
The 5th Amendment, but yes, that's right.
5th. I'm sorry.
Yeah.
Okay.
That's essentially it. Yeah. Something to consider. Well, yeah, sure. But okay, Senator West.
Thank you. Let's start with JPR 10. So the paragraph at the top of page 13, does that have the effect of completely divesting the state's attorneys of the power to conduct investigations? Or is it conceivable that the state prosecutor would conduct an investigation and the state's attorney would conduct his own investigation at the same time?
So we had this discussion when we were drafting this, and it leaves it to the decision point there is in the hands of the state prosecutor. So one investigation will happen, which would be the state prosecutor. So that, yeah.
So if Marilyn Mosby wants to conduct her own investigation of something that happens in Baltimore City, if this bill passes, she won't be able to do that, correct?
She can if the state prosecutor says, hey, we can do this in tandem. You can do it alone. I can do it. So it leaves that decision point to the Office of State Prosecutor. It doesn't mean that it forecloses the possibility. It just leaves that element of just the way that this is drafted. It leaves that element to the discretion of the state prosecutor.
So the state prosecutor is appointed for a 6-year term. And as I read the state prosecutor law, he can only be removed for misconduct.
For cause, yeah.
For cause, right. Suppose we get a state prosecutor who's very, very sympathetic to the police and insists on removing all of these cases from local state's attorneys and then handling them himself. And it turns out that pretty uniformly, he comes to a conclusion that there should be no prosecution. And so let's just say, take your county, the Montgomery County State's Attorney in a really bad case wants to conduct an investigation, feels that there should be a prosecution. Is it under this bill, isn't it correct that the state prosecutor could stop that in its tracks and prevent any independent investigation or any prosecution of a police officer?
Investigation, yes. Prosecution, no. It doesn't touch the prosecution piece. So that's.
Oh, well, wait a minute. You said that, I don't mean to interrupt, but you said that the state prosecutor could preempt the state's attorney. How can you can't
with respect to the investigation? With respect to the investigation.
Yeah, but
not the prosecution.
But a state's attorney doesn't indict a policeman unless there's been some sort of an investigation ahead of time.
So that's what I teased out.
Et cetera.
Yeah, just that's why I teased out the language that was on the top of page 14, because in the normal course of the responsibilities that fall under the Office of State Prosecutor right now, what they do is they do these investigations and then turn that investigation over to, let's say, the Attorney General or the state's attorney to do what they will with it. And so that's the same scheme that's here. So if the investigation occurs with the Office of State Prosecutor, they will then hand that information over to the local jurisdiction, the local state's attorney, to have that information to base to work with their prosecution. So it doesn't touch their ability to prosecute. And in fact, the framework that's being laid out here is exactly the same that's already kind of functioning right now. And so again, I would say that those two things are separate. You've got investigations and you've got prosecutions. This bill does not touch the ability of the state's attorney to prosecute.
Okay, but in my Montgomery County case, the Montgomery County State's Attorney wants to prosecute. He thinks it should be prosecuted. The state prosecutor does the entire investigation and says no prosecution. Now it goes back to the Montgomery County State's Attorney, and the Montgomery County State's Attorney, as I understand what you just said, is not permitted to conduct any further investigation, but can only rely on the investigation done by the prosecutor in making a decision whether to go forward, correct? No further investigation is permitted by the Montgomery County State's Attorney.
It's not, there's not an explicit prohibition. It's still possible. So there's not a barred prohibition. And so there's certainly still the possibility of an investigation. The decision point under the way that it's drafted, though, is left to the Office of State Prosecutor. So it doesn't foreclose the possibility. There's a decision point there. So there's a possibility, and I would suspect a strong possibility of an additional investigation if they wanted to do it after the completion of the Office of State Prosecutor. The point is to ensure that there's an air of independence, that the initial investigation is independent. And so that's the point there, is to make sure that at least you have that first independent step. but it doesn't foreclose it. There's a decision point, right? It doesn't mean it's not possible.
So what you're saying is that the state's prosecutor can preempt the state's attorney from conducting the investigation, but then after the state prosecutor reaches his recommendation, then the state's attorney can go back and conduct his own investigation in order to mount a prosecution?
It's certainly possible if, in the way that this is drafted, if the state prosecutor says go forth, do great things.
Okay. Let me go back into the details of this now. So the state prosecutor doesn't have a large staff. As I recall, it's the state prosecutor and a couple of investigators right now.
It's about 6 people.
Yeah, it's 6 people. It's a very small office. I know it's located in Towson, in my legislative district. So it's nice to have them here. But it's a small office. So if the state prosecutor now is going to take over the investigation of every single one of these police officer violence cases statewide, it looks as if, in order to avoid a big fiscal note, you're providing that the state prosecutor will pull in investigators from around the state to work for him.
So that's right. So, I mean, I think one thing is if you're going to make the decision to have independent investigations, you're going to have to commit some resources toward it, no matter, how you break it out or whatever scheme you're going to operate under. So I think that this model certainly lowers the fiscal note, but there is going to be a fiscal note associated with this. And the expert panel can speak more toward the resources that will be required, but you're looking at, an increase in staff, obviously, because it's a lean staff of 6. So you're going to look to almost double that staff. And yes, you're going to enlist and employ the investigators that are law enforcement officers from across the state. And you're going to pay for that salary time and that expense of that officer that's kind of on loan, so to speak. So yeah, I mean, there is going to be a fiscal note associated, not only with staff, additional investigators that you're going to have on loan and pay for, but also additional attorneys that will have to be employed. So yeah, I mean, you're expanding the scope of their responsibility. You're going to have to invest in the personnel to accomplish the new mission that we're asking them to accomplish.
Okay, so I'm trying to get around my hands around the dysfunction here. So right now, for example, in Baltimore County, you've got Scott Schellenberger, who's the state's attorney. He has his staff of prosecutors. He has a staff of investigators. And
Hey,
they
Scott.
all know each other. Excuse me?
I was just saying hi, Scott. He was waving. Sorry.
Oh, I didn't even know he's there. Hi, Scott. And they all work together. And they know each other's strengths and weaknesses, and they work together presumably pretty harmoniously, where Scott would have something to say about it. And now you're going to bring in investigators and prosecutors from various counties around the state to work on a particular investigation, who presumably have not worked together before. Does that make a lot of sense? Isn't it likely that they're going to have a difficult time getting to know each other, getting up to speed, trying to work together? Whereas if you had the investigation handled by a state's attorney's office, like Scott's office, it would run effectively.
Well, I'd say that, again, the prosecution piece still resides in the initial jurisdiction.
Yeah, we're talking about the investigation.
Yeah. But for the investigation, the bill does not foreclose the possibility, and in some circumstances, I think the probability of enlisting folks that are local and understand kind of like the local culture, the local climate, all that other good stuff, that have the local expertise. But what this does is it separates the publication and the vetting of the investigation as something separate and apart. There's a quality assurance there. And so if you are a member of the public, you can rest assured knowing that there's an independent vetting process going on that's then published and made publicly available to you. So, I mean, that's what I would say. It doesn't foreclose the possibility that you're going to have that local flavor, if you will, or that local expertise involved in the investigation. It just means that there's an independent clearinghouse that's going to publish that information and make it publicly available. Okay,
and then one more question, and then I'll move on. And that is, what happens in Scott's office when one of his ace investigators comes to him and says, I'm in the middle of 4 investigations, but you're going to have to reassign them because the state prosecutor has just told me I have to come and work for him for a while.
And we had that conversation. So there's nothing that there's no compelling, right? They can't really require, hey, you've got to have officer X, Y, or Z come in. And frankly, there's nothing right now in the bill that says that hey, if I go to Howard County, you've got to give me an officer from Howard County. Like Howard County can say, hey, no thanks, I'm not going to participate. So they still have full discretion to participate and to put their investigator on loan, so to speak.
Okay. Next page of the bill, the top paragraph on page 14 says the state prosecutor shall make a confidential report of the findings to the state's attorney. But your new language down in subparagraph C says that after the completion of the investigation, the state prosecutor shall place a report on its public website. So how can the report be confidential up on the top of the page and put on the public website down below?
Because they're two separate things. So I highlighted the language at the top of 14 just to show you that this is a process that this office is currently engaged in and is well practiced in. The language on subsection C deals with the new responsibilities that we're tasking them with. So while the public corruption cases, for instance, are confidential and provided to the state's attorneys and to the attorney general, the new mission that we're tasking them with, the results of that investigation are public. So I only highlighted that initial language to show that this is an exercise that the office is currently engaged in, and that they can do this and that they are well practiced in doing this.
So even if the officer is found to be blameless through the investigation, it's still going to be put on the public website, so anybody can read about that officer.
Well, it goes back to a conversation we had yesterday about record 2, or if you're charged with a crime, like I'm going to go on case search and I'm going to see Chris West was charged with this, but then hey, there was a finding of no guilt. So it's the same concept, but yeah, that information will be there. It'll be a full breadth of information that exonerates that charge.
I just note that if a claim is filed against a state legislator, it's handled extremely confidentially. And if the legislator is not found to be guilty of anything, no word of that ever leaks out to the public. But
I wonder why that's the case. I wonder why the people that wrote those laws are, I guess we did that. Yeah.
Yeah.
Yeah. Interesting.
So finally, with respect to Senator Huff's comments earlier, wouldn't it make sense to merely assign to the Maryland Police Training Commission the additional responsibilities contained in the last half of your bill, where you form this new commission to try to figure out standards for investigations? If they're already coming up with standards, why wouldn't they just we add to their responsibilities the responsibility of coming up with these standards?
Just because those are just separate tasks. I mean, the board here is only, the jurisdiction of the board, or their focus is only on the new responsibilities that we're assigning to this office. So it's kind of a very narrowly tailored lane that we've given them that only applies to this. So it just wouldn't make sense. So I mean, I guess that's the answer. I mean, it just wouldn't make sense to put it into the Police Training Standards Commission when it doesn't have anything to do with those responsibilities. So, I mean. Okay.
Over to the tort. Let me see. I think Senator Huff pretty adequately covered the Tort Claims Acts. But yeah, I guess he covered that. We can talk about that later. So we're now over to public safety. This is the psychological evaluation. So this would require every single police officer in the state to have a psychological evaluation every 3rd year. So a third of the
as part of as a recertification process, yes.
Right, unless they wanted to retire or something. But if they wanted to continue on, they'd have to be recertified and have a psychological test. So that's basically a third of the entire state police officer force every year has to have this. What's the cost of these psychological evaluations?
I don't have a fiscal analysis of that. I can have we can certainly try to get that for you. But
I know in Baltimore County,
a good base point would be a good base point would be how much, if you have for the initial certification of an officer, which the psychological evaluation is part of, the cost there, you could probably do some math and extrapolate what the cost would be annually. So there's certainly a basis for which to have like an informed number there, but I don't know what that is yet. I can do the math there though. I'll get it to you.
But it'll place a significant additional expense on the shoulders of each of our counties, correct?
I'm not sure it's significant. I couldn't tell you one way or another, if I'm being honest with you.
Okay. And I think that's the end. Thank you. Oh, now, wait a minute. I got a couple of questions for Senator Sidner, if I could. Charles, are you there?
I am.
Okay, let's see. The first bill was the camera bill. So it appears simply to require the custodian to grant inspection of the cameras of the video footage by anybody who asks for them. In Baltimore County, I mentioned yesterday, I think the head of Fraternal Order Police also mentioned that last year we had 750,000 interactions between police and citizens. And in Baltimore County, police are required to wear their body cameras and turn them on every time there's an interaction. So that would mean 750,000 videos. Suppose somebody came to the Baltimore County, to the custodian and said, I want copies of every video. How much would that cost? And you don't seem to have any standards for differentiating videos which are needed between videos that are just wanted. And who would pay for all those videos to be copied and made available?
As I had made mention, I'm open to modifications to this bill, but that the incident or the question that you're asking is something that has actually happened in, I believe it was in Seattle, Washington, back when it initially had its body camera program. But what I'll say is this, when the body camera program was put into place, the understanding was you have public resources going into this program. Henceforth, this is a public resource. It is not, while the custodian would be the law enforcement agency who has that body camera footage, it is still footage, it's still the public's footage. So with regards to cost, I believe it's the custodian that dictates what the cost is. I believe there was just an article that had come out about a public information request by with the state's attorney's office, and we have enough professionals or law enforcement here today, but I believe it's them who dictate what the cost is. And in fact, it's at sometimes we've seen where the cost has been used more as a sword to try to prohibit or prevent folk from getting body camera footage. Again, the purpose of this is to get that type of footage out to the public. It is the public's information. But
wouldn't it make sense to put some limits on either the footage you would be in the footage, or a close family member would be in the footage, rather than simply saying, I want all 750,000 tapes turned over to?
No, you make a good point. This is why I say this is a starting point. I would say that for 2 years when I was in the Maryland House of Delegates, I worked with MACO and law enforcement, as well as some of our advocates with, who deal with people who've been in, who are advocating for victims of sexual assaults and things like that. So just because of the way the timing worked with this particular piece of legislation, I was unable to take and do a comparison between this language and language that had been worked out before. So this is one of those bills that is here for discussion that come January, I could see there being some substantial changes to it. In fact, I believe one of my witnesses also has some additional suggestions. So this is certainly not in the final form that you're going to see in January.
Okay, great. Let me go to the last bill then, which was JPR 9.
Yes, sir.
And this is the one dealing with the presumption of inadmissibility. And your key operative paragraphs on page 7, and it says the knowing and willful failure of a police officer to activate a body camera. Suppose the officer says, yeah, I do it 99% of the time. On that case, I just forgot to turn it on. How do you establish that the officer knowingly and willfully failed to turn it on, as opposed to just made a mistake, an innocent mistake?
If it's an innocent mistake, I mean, obviously it's going to be up to the state to make that up, but as in the defense to, it's up to the state to actually prove it to get it in. But I would suggest from the policies that I've looked at, and I've looked at both Baltimore City's as well as Baltimore County's body worn cameras, and they're supposed to cut them on. And I mean, if it's a mistake, it's probably a policy violation that they'll be disciplined for. However, the policy argument is that our local governments are putting a substantial amount of money into ensuring that that our officers are wearing and not using their body cameras in order to capture these different types of interactions or engagements with civilians. And when they don't do so, it lends to there being certain credibility issues coming into the court. So this presumption essentially kind of just codifies what it is or what those expectations are.
Well, let's talk about the presumption. You establish a rebuttable presumption that any testimony that would relate to something that would have been shown by the body camera is inadmissible. And the next paragraph says the presumption may be rebutted by showing of malfunction, of camera malfunction, basically. Right. Does that mean that that's the only way that someone can rebut, by showing a camera malfunction, or are there other reasons why the presumption could be rebutted?
It would go by the language of the bill. And what I'll make note to you, I know within Baltimore City's policy, and they have within it, before officers are going out with their body worn camera, they're supposed to check and make certain that their equipment works. So there should be no reason that the camera should be malfunctioning, because if again, prior to them going onto the streets, if there is a malfunction, they have some standards in place where they're supposed to turn that equipment in and get operable equipment. So really the hope is that it's not going to malfunction, but that's certainly a good reason why video footage isn't captured, and certainly a reason that should not be held against law enforcement.
Well, let me give you a hypothetical. But it's not hypothetical, it actually happened. Okay. We've all seen the footage of in Los Angeles, that person approaching the police car and taking out a gun and shooting it through the front window and seriously wounding the two policemen. Fortunately, neither of them died. Right. But if there were a trial, if they eventually apprehend the person who did it and he stands trial, probably the policemen did not have their body cameras on. Would they be permitted to testify to identify the person who shot them? Or would their testimony, if this were the law in Los Angeles, would their testimony be excluded and as inadmissible because the body cameras weren't on?
I would suggest that if we had a prosecutor like Scott Schellenberger prosecuting that case, those people would not get off because the body camera footage was not activated. No, but there's no.
I'm looking at the bill.
It's not knowing. It's not willful.
Okay. So their argument is we did not have our cameras turned off knowingly and willfully expecting to be shot.
I see that evidence coming in.
Okay. All right. Thank you.
Thank you.
A lot of love going on in Baltimore County right now, so it's good to see you guys. So I think we have now Senator Baltimore County, Senator Heddleman. Another question.
Thank you, Mr. Chairman. If I have a question for you about Bill number 10. It sounds like you were inspired to create this bill because of the MOU that exists between Montgomery County and Howard County in terms of their shared investigations and their recognition that they shouldn't perhaps in certain circumstances be investigating their own. And with regard to my colleague, Senator West's questions earlier about when investigations stop and start and when prosecutions can start and stop, can you tell us a little bit about how it works there now as currently structured?
So for the Howard County, Montgomery County So it just essentially, if something happens, then let's say you have a case, officer involved shooting, for instance, that will then get referred, the investigation, under the MOU just gets referred to Howard County. They have someone that's assigned there. The cost is borne from Montgomery County. So they pay for their own kind of cross investigation, but that's essentially the framework. So that investigation happens, it gets completed, turned over to McCarthy, and then he can proceed and move forward. And so there's local control over the prosecution, just an element of transparency and independence in the investigation. And frankly, the way that the testimony went when we were talking about this, or when the county council was talking about this, was that people really were invested in this idea and liked it, from all ends of the spectrum, that it was something that would reinforce and instill a sense of confidence in the system. And so we've had some high profile incidents in Montgomery County that have been, I think, addressed fairly and transparently, and have, I think it's been a model of success. And so obviously this model is a little different, but the end goal and the process is still the same in terms of that independence, but still leaving to the locals their ability to prosecute. So yeah, that was the genesis of it, and I think it's worked well, and I think this will work well as well.
And do you have a sense whether there have been recommendations that have not then been acted upon by the state's attorney? I'm
not aware. I couldn't tell you with 100% certainty, but I'm not aware of any. I'm certain, just given the public nature of the information that's produced through the investigation, that would have heard. That would have been called out, right. But not that I'm aware.
Okay, thank you.
And I'll just say to the prosecutors I see Scott Schellenberger, Howard, I love you guys. I know you're mad. I'm making everyone mad this week, but I still love you guys. I hope you have some love for me too. But all right. It looks like we are. Are there any more questions from the committee? Okay, great. So now we'll move on to the panel, and so we will start off with Mr. Howard.
Good afternoon, Mr. Chairman. I assume you can hear me. Make sure we're good. Excellent. Good afternoon, Mr. Chairman, Mr. Vice Chairman, members of the Judicial Proceedings Committee. My name has been mentioned, is Charlton Howard. I'm the Maryland State Prosecutor. I am here with Deputy State Prosecutor Sarah David to talk to you about our office and our proposed role in the independent statewide investigation and prosecution of police misconduct resulting in death or serious bodily injury. We're grateful to you, Chairman Smith, and to so many of you for your work on this important issue. Maryland State Office of State Prosecutor is the only one of its kind in the country. It was established in 1976 to conduct independent, nonpartisan investigations and prosecutions of sensitive cases, including misconduct in office by public officials. Just to address one concern, we currently have 13 personnel, 4 prosecutors, 4 of whom are prosecutors, 7 are investigators. JPR 10 does not significantly expand our legal authority, but it does expand our potential scope of work. We have the necessary jurisdiction and independence to address any official misconduct, including police use of force violations. Given adequate resources, we could take on this new role. Our office endorses an OSP-led task force model, such as is envisioned in JPR 10. This would be similar to that utilized by various federal task forces, including the current one for public corruption in the state of Maryland. To ensure that we consistently employ best practices and engage with community stakeholders, we also endorse the Police Criminal Misconduct Commission, including JPR 10, to provide the office on policies and best practices and provide diverse perspectives on police accountability. We acknowledge problems of systemic racism in law enforcement and endorse a system as reflected in the bill to ensure that hiring and recruitment of prosecutors and investigators engaged in this vital mission reflect the diversity of our law enforcement agencies and the communities they serve throughout the state. We acknowledge the state's attorney's concerns with centralizing those investigations and prosecutions in our office, and some of those concerns expressed by several of the legislators. There is, however, I want to assure everyone, no threat to the constitutional prerogatives of the state's attorneys. By statute, we would continue to submit a report of our findings and recommendations on any misconduct case to the local state's attorney where the incident occurred. And that state's attorney would be entitled to take that case on and charge it, to conduct additional investigations, or if our recommendation is not to charge the case, to follow that recommendation. They have the opportunity and the responsibility, if they so choose, to follow through on cases, even if we recommend no charges. Prosecutions and investigations cannot be divorced if we want to create a predictable and professional process throughout the state for both police officers and victims. That's why I believe that our office's role presents a unique opportunity for such a program, because we have a vested in practices of integrating prosecutors and investigators from day one of investigations. I know the time today is limited. I'm open to continuing the conversation in the months to come. I can also happy to address any of the questions that come up already or any others from the panel. Thank you, sir.
Great, thank you very much. Any questions from the committee? All right, seeing none, thank you very much for that, Mr. Howard. We'll now move on to Mr. Hansel. Carrie, floor is yours. I think we got to unmute you. There you go.
Thank you, Senator. I appreciate the opportunity to testify here today. I'm a civil rights lawyer. I've been doing this work in Maryland for 20 years. I am testifying in favor of permitting full recovery for economic damages in cases of state violence, and also increasing the cap for non-economic damages on an annual basis by the small amount mentioned in the bill. These changes will bring this cap statute in line with other cap statutes in Maryland. So for instance, under the personal injury cap, the wrongful death cap, the survivorship cap, the medical malpractice cap, non-economic damages are not included, and the cap, to account for inflation, automatically increases every year. So these are simple and fair choices that this body has made again and again. With respect to these particular cases, let me offer you a brief story about one of my clients and why these changes are so important. I represent a young man in his 20s who was rendered a triplegic and mute as a result of civil rights violations. He will use a wheelchair to get around for the rest of his life and be entirely dependent on others for the entirety of the rest of his life. The man will unfortunately never work and never have the privileges and advantages the rest of us do in society. His medical bills far exceed the cap. His lost wages far exceed the cap. And under current law, civil rights claims are set alone in Maryland with respect to having that cap apply to actual out-of-pocket losses. So this man, in addition to being in a wheelchair for the rest of his life, will never recover his actual out-of-pocket losses in terms of lost wages and in terms of medical expenses. And that leaves this cap standing alone and unlike other caps in Maryland. Even with this change, even permitting the fair recovery of actual damages, which are actually suffered, these are economic out-of-pocket damages, even allowing for that, the non-economic cap would remain in place and would permit for less than half of the recovery for civil rights victims, the victims of other types of misconduct in Maryland receive. So this cap would still be less than half of the other caps. We know that civil rights violations are disproportionately visited upon people of color and other disenfranchised groups. So what this cap does currently is weave into Maryland law racism and classism like some kind of invisible string that most people never see. And we have the opportunity today to solve, or you have the opportunity today to solve that problem, to rip it out, to make sure that this cap does not have the classist, racist effect that it currently has, and to bring civil rights claims into compliance with other claims in Maryland. To those who would suggest that the cost of justice is too high, I will remind you first that the entities that were mentioned, like Mount Airy, are part of what is called the Local Government Insurance Trust, which has existed since 1987. It is in effect a pooled resource of money with billions of dollars under management. So the $5 million budget of Mount Airy that was mentioned earlier would not be touched because Mount Airy is now and has for many years been a member of the Local Government Insurance Trust. as were the other small towns in almost every small town in Maryland.
Mr. Hansel,
Yes.
you're speaking on my bill, and I love what you're saying, but I have to be fair to the rest of the panelists, just with our time. So
Thank you,
I'm gonna ask
Senator.
you to briefly conclude, and we'll move on. Sorry.
Thank you,
Love what
Senator.
you're saying.
Thank you, Senator. I will very briefly say that those who are concerned about the cost of action must consider the cost in lives and injustice of inaction. Thank you.
Thank you very much for your testimony. Definitely want to follow up with you about that, the fund, but we'll do it in the Q&A section. Next, we have Miss Headley, Andrea Headley. Doctor.
Good afternoon. Thank you for bringing me here to speak. I am Dr. Andrea Headley, and I'm an assistant professor of public policy at Georgetown. I'm not here to provide remarks really on the specific details of the language in the bills, but rather to share my general expertise working with police departments and examining body cameras with regard to both JPR 8 and 9, as brought forth by Senator Sidner. I'm going to do my best to stay around 2 minutes, and then I can provide written testimony afterwards. Body cameras have gained increased prominence as a means to ensure transparency and accountability. The quantitative results on the efficacy of body cameras is mixed, and it differs across studies, meaning sometimes cameras lead to impacts for officer behavior and civilian behavior, and other times there are no effects found. However, the big takeaway from the larger body of research is that effectiveness is context dependent and implementation specific, meaning how they are used matters. There have been arguments made with regard to the importance of public access to footage in a timely and efficient manner. Speaking as a researcher and a scholar, it's hard to understand effectiveness of cameras if there are not policies and laws in place that allow public access while also respecting privacy concerns. More specifically, standards for checking footage regularly is important for ensuring the fidelity of implementation, and qualitative studies also demonstrate public appreciation for the evidentiary value and public scrutiny that body cameras can allow. Turning briefly to enforcement and compliance, research also suggests that departments with more restrictive discretion and activation policies often have greater reductions in use of force and have greater reductions in complaints as well. Yet concerns exist with regard to selective recording, which can open up potential for misuse of camera technology. In police departments where body camera activation is required for all or certain interactions, then there should be some type of consequences for not activating as a means to encourage compliance, bolster accountability, and potentially augment crime clearance. I do have one concern with regard to JPR 9 that I think merits further consideration from you all, but I will reserve that for the Q&A. In summary, while I am a scholar who studies policing, I also study management and implementation practices in public agencies broadly. And what we do know is that technology is only as good as the person who operates it, and that inadequate implementation or improper use makes transparency and accountability difficult to actualize. Thank you.
Thank you, Dr. Headley, and we'll definitely note that for the Q&A period. So thank you for that. And Senator West, we're going to hold the questions till the end. So just make sure we, I got you though, noted down. So thank you, Dr. Headley. We'll now move on to Mr. Franklin, Neil Franklin.
Thank you, Senator. Again, thank you for having me. Hopefully the committee remembers my introduction yesterday, so I won't cover that as to my background. However, I'll be speaking to two bills, JPR 8 and JPR 9, both dealing with the body-worn camera. Transparency is the utmost importance, and that's what both of these bills are about. Video evidence, whether it's from a body cam or a citizen's camera, has brought an important level of transparency into policing. I support JPR 8 intent. However, I would like to see it tightened up a bit. Its current general state permits too much subjectivity when it comes to redaction or prohibiting inspection by the custodian. Yes, we get victim privacy. Fair trials are very important. However, what constitutes a person's safety? And what can prejudice an investigation? It's quite broad, and it allows too much subjectivity on part of the custodian, in my opinion. Unfortunately, when it comes to the Public Information Act, police departments have an unfavorable reputation of stonewalling requests. It's getting better, but we still have a problem there. As for JPR 9, We have and continue to see, unfortunately, evidence of police officers failing to activate body cams, turning them off during critical times when interacting with citizens. We have also witnessed a collaborative effort, a conspiracy at times, of police officers turning off body cams, even at the direction sometimes of supervisors on the scene. So this is about intent to not record, not the accidental failure to record. And I think showing that intent is very important. Whether intervening, reporting misconduct, or access to video capture, police body cams are very important in establishing public trust. And I know my 2 minutes is up, so let me wrap it up real quick. So every opportunity that we have to enhance transparency in policing cannot be ignored. And just in closing, yesterday there was a comment regarding law versus police policy. Why do we need law? Why can't it just be policy? But understand that the foundation of police policy is law. So we look at state law, we look at federal law, and then we craft our policy so that we're in compliance with law. Thank you very much, Mr. Chairman.
Thank you very much. Good to see you again.
Always a pleasure.
Next, we have Stanford Fraser. Ms. Fraser.
Good afternoon. I'm here. My name is Stanford Fraser, and I'm a public defender in Prince George's County, where I practice as a trial attorney. I'm speaking on behalf of the body camera legislation presumption of inadmissibility. In my practice as a trial attorney, I've dealt with lots of cases involving body camera evidence. And unfortunately, I've had cases in which officers are verbally, as well as giving hand signals to each other, to mute their body camera, or to move officers that are not wearing cameras, signal officers that are wearing cameras to walk in a different direction or go in a different area as they discuss the case or do other actions to effectuate an arrest. I think in these circumstances that strong consequences in court are necessary to punish officers that obstruct or hide, or I would consider purposely muting your body cameras during arrest as destruction of evidence. And I think those type of consequences, right, those consequences would incentivize and force officers, as well as the state attorney's office, to maintain this evidence and to actually practice transparency through their practice. Thank you.
Thank you very much. All right, next we'll have Ms. Rothstein, Melissa Rothstein from OPD.
Thank you, and good afternoon. My name is Melissa Rothstein. I'm the Director of Policy and Development at the Office of the Public Defender, and I'll be testifying on JPR 8. Our office confronts police misconduct every day, and we see a real need for greater transparency, both with disclosures to our office and with the information provided to the public in order for abuses and patterns of misconduct to come to light and potentially be addressed. Body-worn camera video is a valuable tool in improving transparency and accountability. In addition to the reasons that were stated earlier by Dr. Headley, it sometimes provides a record of abuse or misconduct and more generally illustrates how police officers behave and respond, both when adopting appropriate practices and when they are not. However, these videos can only shed light on abuse, misconduct, and problematic practices if they are shared. Examples both within our state and across the nation confirm that the police cannot police themselves. And the public needs all of the tools available to improve the outside accountability that has been lacking. In the Public Defender's Office, we receive body-worn camera videos in litigation through discovery. It has enabled us to verify client claims that would otherwise be discredited and has brought attention to misconduct that would otherwise go unaddressed. Subject to safety, privacy, and constitutional protections, outside entities also need access to these videos. Not all misconduct and abuse will result in a prosecution or have evidence disclosed through discovery, and individual criminal cases are not effective avenues for addressing patterns of abuse or seeking systemic reform. We firmly support any effort to improve transparency and accountability and appreciate the Senate's consideration of these important issues. Improving access to body-worn cameras videos is not a cure-all, though. Even within the realm of improving transparency, allowing IAD files to be disclosed under the MPIA is an urgent and important need. However, removing barriers to public availability of body-worn camera video is a step in the right direction. Thanks. Thank you.
All right, thank you very much. And next we have Mr. Roca from the ACLU.
Thank you, Chairman Smith, members of the committee. I'm here to testify on JPR 8, 9, and 11. I'll go quickly given the limited time. Regarding JPR 8, we support the principle that body-worn camera footage should be disclosed. That, of course, is the whole reason that there was a public demand for body-worn cameras, and the whole reason that body-worn cameras have been adopted in police agencies throughout the state and throughout the country. Their purpose is to provide transparency in police actions. But with respect to this bill, it's important to understand that the only reason that I'm aware of that such footage might not be disclosed that this bill addresses is the fact that it is contained in an internal affairs record. And the claim is therefore made that because it is part of an internal affairs record, it can't be disclosed because of the Court of Appeals decision in DeShiel saying that an internal affairs record is a personnel record. The way to address that problem is not to take a piecemeal approach by type of record, but to fix the mistake that the Court of Appeals made by treating internal affairs records as personnel records, and to instead treat those as investigatory records, which is the principle that this bill does. The 7 exceptions to disclosure here are the same exceptions to disclosure that apply when a request is made for an investigatory record by a person in interest. I would note also that if the General Assembly does what we have been suggesting, it would not mandate disclosure as this bill does, but would allow it and would also require that if it is withheld, there be a sufficiently good reason. With respect to the question that Senator West raised about blanket requests, of course, as I noted at the beginning of my testimony, body-worn camera footage can be requested now, has been requested now as investigatory records, and this theoretical concern about blanket requests has not come up in a single jurisdiction in Maryland. And in any event, in Maryland, the cost of requests is borne by the requester. So anyone who recorded all 750,000, et cetera, body-worn camera footage would have to pay for them, rendering it impossible. With respect to JPR 9, we support the presumption that an officer should not be able to testify if they willfully fail to turn on a body-worn camera. The fact that the presumption here would apply only if the failure is willful and knowing solves, I think, the possible objection that has been raised about the presumption being able to be rebutted if the failure to activate was because doing so was either impossible, impractical, or accidental. But what this bill does not do, and what we think would be necessary in legislation about this, is make clear where the burden of proof should lie. Since it is the state's attorney's office that would be offering the officer's testimony, the burden should be on them to establish that any failure to activate a camera in violation of policy was not willful. Finally, as to JPR 11, regarding the raising the tort claim limits for victims of police misconduct, we support that. Victims of police misconduct should be made whole. Doing so would encourage residents to bring these types of cases in state court as opposed to federal, where there are no liability caps, which is something that the General Assembly should want to encourage.
Thank you, Mr. Roca. Good old 1983. All right. With Sheriff Barry is next.
Good afternoon. If it's okay, I am going to jump in first in front of Sheriff.
If it's okay with Sheriff Barry, I'll defer to, yeah, there you go.
That's perfectly fine, Chairman. Thank you.
All right. Thank you, Mr. Chairman and members of the committee. I'm Melissa Hyatt, Chief of the Baltimore County Police Department. As Chief Neske said yesterday, our organization looks forward to working closely with you on these important issues. Based on our experiences as leaders in this profession, we stand ready to recommend some alternative approaches and work cooperatively to develop proposals to increase transparency, accountability, and perhaps most importantly, trust in our communities. In regards to JPR 8, we are supportive of body-worn cameras and champion programs that bring about trust, transparency, and confidence. Many of us have experienced successes with our programs. Just over a year ago, my own agency worked with stakeholders on a body-worn camera release policy, and many other organizations similarly have policies in place. We believe that police departments with body-worn camera programs should adopt a release policy and are eager to work with members on recommendations, understanding that each agency's release policy should both meet the needs of the community and the necessities of that jurisdiction. Maryland chiefs and sheriffs support the concept of this bill, but careful examination and amendments of specific provisions will be necessary to ensure that requirements are appropriate and to avoid problems from unintended consequences. Unfortunately, JPR 9 is not something that we can support. It fails to take into account those split-second emergency and exigent situations that confront our officers. There are situations where officers stumble upon crimes in progress and must take immediate action. For example, an officer might be going into a restaurant for lunch only to discover an in-progress robbery, or an officer pulls into a neighborhood and encounters a shooting or another serious crime in progress. An officer may be so focused on suppressing the crime or rescue and protection efforts that they may forget to turn on their camera. This bill would make the witness officer's testimony inadmissible. As chief, when there is a critical incident which should have had footage available and there's a failure to activate a camera, I take that seriously and investigate the circumstances, holding my officers accountable when appropriate. However, the adoption of this bill could result in the denial of justice for victims of crime and also for persons accused of crimes. Further, a police officer that makes a simple mistake or fails to activate their camera in the heat of an unfolding moment should not impact that officer's ability to testify to the facts of the case. A civilian in the exact same circumstances would be permitted to testify, and a trained police officer should as well. JPR 9, if enacted, would have disturbing consequences and would have an adverse impact on the safety of our communities. I look forward to answering your questions.
Thank you, Chief Hyatt. And next we'll go with Chief Barry, or Sheriff Barry, sorry.
Thank you very much, Chairman, and also the members of the Judicial Proceeding Committee. Again, I'm Sheriff Barry with Charles County Sheriff's Office. I want to thank you for this opportunity to give some very brief remarks regarding JPR 10, JPR 12, and JPR 13. Regarding JPR 10, I have a number of questions, and some of them have already been answered, but I just want to state it for a point during my presentation. The bill states that the State Prosecutor Office will establish a pool of investigators to investigate alleged criminal offense committed by a police officer. In addition, the bill states that the investigator shall be a police officer employed by a law enforcement agency of the state. As the chief officer of my agency, I'm concerned about unfunded liabilities. As I know, these particular investigations require a lot of staff, a lot of overtime, and specialized equipment. And we must be able to have a conversation about if we were to have a task force type of principle, being able to deploy a number of my resources outside my jurisdiction for a situation and not having those resources available in my jurisdiction to be able to address or mitigate any issues in my community. And the other issue I have a question about, in a deadly force situation, does a law enforcement agency have an investigative role in any incident that happened in the community? Or does a law enforcement agency simply has to wait for a state prosecutor office to respond or an assigned investigator? And the reason why I'm concerned about that is this: there could be loss of evidence and communities' concerns regarding timely removal of a deceased person's remains. And also, as an elected official, being able to have given timely information concerning the status of an investigation to the citizens who duly elected me to this community. I have a number of managerial, financial, and also logistical questions for JPR regarding this bill, and we can discuss it at a later time. For the record, the Maryland Chiefs and Sheriffs are willing to explore a parallel investigation procedure or a process to review use of force investigations. Regarding JPR 12 and JPR 13, the Maryland Sheriffs and Chiefs need more clarification regarding the issue at hand and more time to consider potential consequences regarding the suggested legislation. In closing, the Maryland Chiefs and Sheriffs are committed to working with the citizens, local leaders, and General Assembly members to bring positive enhancements to Maryland law enforcement in the state. Thank you, and I'm available for any questions.
Thank you, Sheriff. And Next, we'll move on to Mr. Boatwright. Clyde.
Good afternoon. Am I unmuted? Can you hear me? Sounds good. Okay, great. Mr. Chairman, distinguished committee members, I promise to stay under the 2-minute allotted time. My name is Clyde Boatwright, and I'm the newly elected president of the Fraternal Order of Police Maryland State Lodge. I want to take this time to thank you for allowing me to be a part of this discussion on the proposed reforms in policing. We here at the FOP are committed to a collaborative approach towards sensible solutions in reforming our profession. However, we must be aware of the unintended consequences that may arise as a result of the work we do with this legislation. As stated yesterday by our General Counsel, Mike Davey, we're not here to be in opposition to all of the proposed changes to how policing is done here in Maryland. We believe strongly in due process and the presumption of innocence for everyone, to include our police officers. We're here today as the voice of the over 20,000 men and women in uniform who are working hard to protect our communities and need your support. We look forward to being a working partner and adopting best practices beneficial to everyone. I will gladly stand for any questions. Thank you.
All right, thank you, Mr. Boatwright, and congratulations on your election.
Thank you.
Next, we'll have Mr. Consoli of Angelo.
Good afternoon, Chairman. Thank you for having me. For those that don't know me, my name is Angelo Consoli. I'm the president of FOP 89, which is Prince George's County, and I'm the newly elected second vice president for the Maryland State Lodge. I thank you for the opportunity to be involved in this process. As Clyde said, we are here to be involved in the process moving forward. In reference to the specific bills within themselves, I would echo the sentiment that Chief Hyatt said as far as body-worn cameras. It is something that in Prince George's County we are moving towards. For the last 3 years, we have been a proponent of it and pushed for it. And I think with the release, obviously with the videos, there needs to be the release of the videos, but it has to be done properly and with caution. I guess with the issue with some of the bills is that on a lot of the police bills that we do, I've mentioned it before to other senators and delegates that it's kind of gets upsetting at times that we put bills in and we don't ask the people involved, i.e. the police officers, for input in these bills. A lot of times it goes a lot further if we can have the input with the bill to help you craft a bill that we can work together based on our training experience and our knowledge. Baltimore County's had the cameras for quite some time, and that would have been a good starting point for some of these laws in reference to the dissemination of the footage. As far as the admissibility of the evidence, where it becomes, it seems like there's a pattern in some of these bills that the assumption has to be against the officer and that all officers are doing wrong. That is by far the case. I think even the statistics have shown that 99% of the police officers in the country do their job and do the job well and do it professional. We've had vehicle camera systems in Prince George's County for many, many years, and it shows just that. And I believe the body-worn cameras will show the same thing. We don't do anywhere else in the criminal justice system do we not allow somebody to testify based on any action they took, and I don't believe we should do so in the case of an officer, especially where we know that the burden of proof is going to be on the officer that it was not an accident or that it wasn't due to the circumstances that it wasn't turned on. And on a case where it is me and one other person involved in that issue, if I don't turn my camera on, I now can't testify. I think is way too harsh, and it's not done with anybody else. And with that, I'll keep it short and stand for any questions on any of the other bills as well.
All right, great. Thank you, Mr. Consoli. And last but not least, we have Mr. Schellenberger.
Mr. Chairman, members of the committee, thank you so much. One thing I need to make clear right at the outset is today I'm speaking for myself, not the MSAA. You may hear from some of my fellow state's attorneys who have slightly different position on one or two of the bills. So I want to make sure that's clear. At the risk of giving everyone a heart attack, especially my friend Senator Sidnor, I am not opposed to JPR 8 as drafted. In fact, JPR 8 is the actual policy here in Baltimore County for body-worn cameras. We have been slowly working on that policy, and it has been tweaked. And as Chief Hyatt indicated, it was tweaked again this year. But I am not opposed to 8. And in fact, I can tell you that there may need to be another carve out. We may want to create a public safety reason to release the video. A couple years ago, we had an officer involved shooting. It was rather controversial. The citizens in that area of the county were very upset. There was some talk about some protests. I reviewed the body camera with my top people, and I, along with the chief, who wasn't Chief Hyatt at the time, we determined that the officer's actions were justified. We released the video, and it calmed everything down because of the way it got released. So we do think that there can be times where, in order to keep public safety, we can release videos before some of these exceptions. So I'm in favor of JPR 8. JPR 9, I'm opposed. Body-worn cameras were the best thing that we ever did. I wasn't always a big fan. It comes with a big expense, particularly for my office when you look at the redactions, but it was one of the best things that we ever did. But everybody makes a mistake. I would ask everybody on the committee, have they ever been on the floor of the House or Senate and actually hit yes and asked if they could change it to no? Or had accidentally hit no and asked if they could change it to yes? Accidents happen. And I think an officer has a right to not have, accidentally not have hit the start feature. The other things that's important to know is that there should at least be a public safety exception. And that is if the officer didn't turn it on for the safety of themselves or for others. The thing that we have to remember is, look at the case in LA that Senator West tells us about. 2 officers sitting in their car, their cameras were not running. They get shot. This would prevent them from testifying because they have cameras, they weren't running. And I keep hearing about accidentally forgetting, but when I read JPR 9, the only exception I see is for us to prove that it was a malfunction, not that there was an accident or a mistake. Finally, JPR 10, the first thing we have to get clear is most states' attorneys' offices do not investigate crimes. We review what some other agency has done. So this constant talk about states' attorneys investigating, that just isn't done, at least in the major jurisdictions. I do, in fact, have investigators working in my office, but they work for the Baltimore County Police Department. So that is not, what you are seeking, which would be an independent investigation. But more importantly, I was elected, and all my fellow state's attorneys were elected constitutionally to prosecute all crimes in my jurisdiction. And that includes if police officers are the individual who committed the crime. And therefore, I think it's my duty to do that and not give it to my friend, State Prosecutor Howard, who's very competent, has good people, can obviously do it. But I do believe the fiscal note would be extremely big. You're now talking about the state prosecutor handling every police involved incident of violence and shooting in 24 jurisdictions all over the state. And that would also entail, I see your lights on, I'm gonna stop. That would also entail, if they have to go try a case on the Eastern Shore, they have to go down there and live for, maybe a week or 2, whereas our local jurisdictions don't do that. So I think the fiscal note would be very good. I need to justify everything to my electorate. And if I don't do a good job on prosecuting these cases, I don't get elected. And therefore, I think it should stay with each state's attorney. Thank you so much. Happy to answer questions.
Thank you very much. Okay. And I gotta say, I liked Mr. Howard's testimony, not just because he's a Navy man, but it was solid. I liked it, But all right, we'll go on. Senator West has the first question in the queue, and then we'll go to Senator Sidnor next.
Thank you, Mr. Chairman. First of all, Dr. Headley, are you still with us? Great. You said you had one concern about one of the bills, but you said you'd wait to relate the concern till you got asked about it. So I'm asking you about it now.
Yeah, thank you for that. And so I guess my concern is that currently my understanding is there is no state legislation that requires police departments to actually, all police departments in Maryland to actually adopt body cameras. And there are no, and please correct me, I could be wrong here, but my brief understanding is that there are no state policies that also require all departments to, that have cameras to actually activate them. I'm not necessarily saying that that should be a state policy, but I want to acknowledge that, like, if that is kind of the current where we are with policies, then I wonder what type of deterrence a policy or legislation like JPR 9 could lead to for police departments who are still weighing whether or not they would even consider body cameras and whether or not they want to have a required activation or whether or not they want to give more discretion, particularly because the research shows that when there is less discretion and there are, the policies within departments are very clear about when you should activate it, whether it's all times or in certain situations, that leads to usually it leads to the outcomes that we want to see with body camera impacts. And so I think if there is any possibility that this could be a deterrent for police departments to have more stricter policies regarding discretion and activation, that should be taken seriously. I will say though, on that in particular, I do think that the concerns brought up by Chief Hyatt and others are important to be mindful of. And because I work with police departments and I hear these types of concerns often, and I've been with police departments where kind of crimes in progress, we've like driven up on crimes in progress. I think it's an important concern, but as a researcher, as someone who cares about numbers, I think it's also important to think about how frequent those types of incidents happen as opposed to officer initiated incidents, such as proactively going to stop, arrest, serve a warrant, and whether or not there could be specific language that maybe makes exceptions to those type of crime in progress, to public safety reasons, as alluded to, or these like innocent, I forgot or what have you to that. I have other thoughts, but I will stop there.
All right, well, that's very interesting. That's a point I hadn't thought of. Your main point is that if we were to pass JPR 9, it might discourage police departments or counties from going the body camera route because it would run the risk that officer testimony would be disallowed at court, right?
That is my question for you all to consider. I think that could be a possibility. Obviously, I don't have the answer to say like whether or not it's a real one. Maybe our law enforcement partners can weigh in here. But I do think it's something to at least consider in terms of going forward with how best to go forward with this while thinking about trying to enforce transparency and accountability.
Great, thank you. Mr. Fraser, you talked about some things and other things I hadn't thought about. So when you turn the body cameras on, it doesn't necessarily mean they're going to be filming what happened. The policeman could turn away. The policeman could act in such a way as to preclude the body camera footage from reflecting what was actually going on. How could we stop that?
Those are good questions. I think the most common occurrence I see is actively muting their cameras during, I can see it on video, they'll point it out like, oh, your camera's on, and then there'll be no sound, right, for 5, 10, 15, 20 minutes. So I know so maybe put in that language if there's evidence of purposely muting your body camera in XYZ circumstances. That's something I've commonly seen in my practice. I think I don't have the language on hand, of course. I'm just speaking from personal experience of what I've seen in my cases, and these are some of the common occurrences that happen.
Thank you. And Ms. Rothstein, are you still with us? Yes, you are. Hi. So I'm trying to think how it would play out in a court setting. I'm sorry, I just lost you again. You were on. Are you with us?
I'm still
there
here.
you are. I'm sorry. Okay, I just couldn't see it. So you see, this is the problem of the remote. If we were in the hearing room, I could definitely see you. So in a court, I assume that the prosecutor would call officer so-and-so. The defense attorney would ask to approach the bench and move that officer so-and-so's testimony be disallowed. Then what would happen?
I'm actually going to to sort of defer to Mr. Frazier again, if he could answer. I'm actually not a litigator. I do our policy work. So
Okay.
I can provide other examples from the question that you asked him previously that we have heard in other places about how body-worn camera is intentionally used to avoid depicting things. So, but on the specific question of how it plays out in litigation, I think he would be able to answer that
Okay,
better.
well, Mr. Fraser, let me pose the question to you then. So a policeman forgot to turn the body camera on, but he saw something extremely important, which is vital to the prosecution. The state's attorney calls the policeman. The defense counsel, I assume, asks to approach the bench and says, we move that his testimony not be allowed. Then what happens?
Yes, it depends on the particular circumstance, but under the law, there are certain discovery rules, things that need to be turned over. And then there's certain rules under the Supreme Court and Constitution that have been incorporated in Maryland. The biggest example for defense attorneys would be Brady, right? Anything that is potentially, mitigating or, exculpatory for a criminal defendant must be handed over. There's also something when it comes to jury trials, there's a jury instruction called the missing evidence instruction, in which the defense counsel can request a negative inference, right, for certain types of missing evidence. So the way it usually goes about
JPR 9, I think it is, says that the testimony is, quote, disallowed.
Yes.
So how would that play out in a court setting?
Yeah, so I think in a court setting, we would play the videotape similar and say, because of these actions, right, or we'd question the officer. Yes, you usually have a body cam. No, I didn't have it on in this instance. We would use the general orders or of the police department, right, to try to cross-examine, saying these are these general orders of how you're supposed to have your body camera on. And then we would ask the judge to either find that there was a discovery violation to exclude the officer's testimony or something similar to that.
And would you end up basically having a mini trial outside the presence of the jury to determine whether or not the officer truly forgot to turn it on or whether there were other motivations involved?
Yes, if it was a jury trial, this would probably be something called a motion in limine. There are different motions that are litigated before the trial begins. So if the trial's set to begin Monday afternoon, that morning, you have certain motions that litigate certain evidentiary rules. Can certain evidence come in? Can certain people testify or not testify? And I imagine this is something that could be handled in a motion in limine. However, another thing to think about is a lot of cases are just bench trials, right? The vast majority of our misdemeanors start in the district court. And this could be something that's actually litigated during the actual bench trial or right before the bench trial is supposed to begin.
Okay. Thank you very much. That's helpful. Thank you, Mr. Chairman.
Thank you, Senator West, and thank you, Mr. Fraser. I just want to now move on to Senator Sidnor.
Thank you. And this is, if I could speak and ask Mr. Fraser a question. Bring him back up. Thank you very much. I think there were probably at least 3 people who testified earlier mentioning exigent circumstances and officers making mistakes and just talking about how because of those types of mistakes that they would not then be able to enter in this information because of this particular type of legislation. But I'm curious, the bill, Section C of the bill reads, the knowing and willful failure of a police officer to activate a body-worn camera in violation of the policy of the law enforcement agency that employs the police officer creates a rebuttable presumption that any testimony of the police officer sought to be introduced in the criminal prosecution relating to the incident that was not recorded is inadmissible. I'm curious, if it was an accident or if an officer was sitting down at lunch and saw a crime occur and then they jumped into action, they had a body camera, but they jumped into action. Do you think that you could honestly say that that was a knowing and willful failure and be able to use that as a way to exclude this evidence?
As a lawyer, I always say it depends on the circumstance. I think if they see someone carrying a giant bomb and while they're eating lunch and walk over there, that's in the moment. I'm not sure. I know they brought examples of what happened to the officers in California that case. I think there's a difference between when you're proactively on duty also versus when you're not on duty. And I think I explained before that I'll usually use the general orders of my jurisdiction to ask officers questions. And I think the policy of when to turn your camera on in those situations are actually included within the general orders. So yeah, I apologize.
Thank you. Same question. Oh, I see County State's Attorney Scott Schellenberger.
Thank you very much. Maybe I'm reading this wrong, but there's a presumption that you can't use it, and the only exception is the malfunction. It doesn't say an accident. It doesn't say it was emergency. Right there on number 2, it says a willful failure to activate it and a violation of policy creates a rebuttable presumption. But the only way to rebut the presumption is to show that it was malfunctioning. So if you want to do something like this, I would ask that you would at least create more things that can rebut the presumption, like officer safety, like safety of another, like public safety. You know, I don't think we need it at all. I understand the concern, but there has to be more to rebut the presumption than just a malfunction.
And just to reply to that, I think in conjunction with the policy. So you have to violate the actual policy. And I think some of those concerns you mentioned are actually included on when you need to turn on the camera in policies in certain jurisdictions, right? Depending on the general order, depending on the actual police department.
Thank you. To Mr. Is it Angelo Consali? You two had kind of mentioned some of those same concerns, but what I'm curious, and this is from a police officer's perspective, when you have incidents of officers that have been documented misusing body cameras, how does one then engender the confidence of the community that these body cameras will be used properly?
Yeah, and it's Consoli.
Thank you.
And that's totally understandable, and that's why departmentally, within the policy, there will be sanctions for an officer that doesn't turn on the camera at the appropriate times he's supposed to, turns it off when he's not. And the assumption for everyone is that they're going to follow the rules, and for most part, I think we're going to find in our location, just as we have with our mobile video systems, that 99.9% of the time you're going to see the officer doing his job, doing it very professionally. And for what a lot of people are actually going to see is the opposite. You're going to see the reactions of the people that we deal with on a daily basis, and see some of the abuses and everything else that we take on a daily basis. But and I think the other good thing within the cameras is that it will make most incidents be at a much lower level, as everyone is aware that they're on camera. The hope would be on any incident that you want to record everything that's there, because at the end of the day, and our MVSs do it, 99% of the cases that go in front of internal affairs that are on video, the officer ends up getting cleared because the video clearly showed that he did the job, did it properly, did it professionally, and that in some of the instances, the incident itself never occurred.
Thank you. Thank you, Mr. Chair.
Thanks. Looking around for any more questions. Seeing we've got one more from Senator West, and then I've got one after you, Senator West. So,
thank you again, Mr. Chair. And I'm sorry to ask the committee's indulgence one more time, but it just struck me that because Chief Hyatt is here, and because Baltimore County requires these cameras to be worn by all their police officers, we have the opportunity to ask Chief Hyatt, what do you do if the police officer has failed to turn the camera on? How is that police officer treated? Is there any discipline needed out?
So if we have a circumstance that's brought to our attention where an officer should have had a body-worn camera activated and failed to, obviously we investigate those circumstances. If you look through our policy, there are some pretty defined circumstances on when they would not have it activated. Perhaps they're dealing with a victim of a sexual assault or certain circumstances like that, very sensitive ones. But if there's a circumstance when an officer should have had a body-worn camera activated and didn't, there is discipline, there are sanctions that come with that. And certainly there have been circumstances that we have charged officers who failed to activate it.
Okay. Would you be able to provide to the committee that little piece of your policy manual which sets forth the circumstances in which the cameras should not be turned on?
Absolutely. I'll be happy to send that after we clear from this.
Thank you very much.
Yeah.
Okay, great. Looking around for more questions. I don't see any more. I have one for Mr. Howard, and it just goes back to the discussion that we had. It's on JPR 10 about just public accountability. So if we go ahead and pass this bill, if you could just talk a little bit about the merits and the benefits of the appointed position vice elected, but then also the mechanisms of accountability, meaning that if there's any sort of conduct within your office for you personally, what are the reasons that you could be potentially removed, and what does that process look like?
Certainly. Well, if let me address the second question last. Under Maryland law, Section 14-102 of the Maryland Criminal Procedures Act, which is in the body of statutes covering my office, the state prosecutor is an appointed position, but it's fairly unique within appointed positions in that there's a specific commission set up to appoint that position, drawn with a diverse membership of people who are recommended by the Senate, the legislature, the Maryland State's Attorney Association, appointed by the governor, and the Attorney General. And then they nominate an individual to the governor. The governor has 30 days to approve that nomination or reject it. And I'm summarizing here, but essentially one of those nominees is then approved. So there's parallels somewhat to the judiciary, but also it's not just a pure political appointment. There's a vetting process that goes through. And then once you're appointed, it's for 6 years, and then you can only be removed for cause, essentially, and essentially only on the recommendation of the commission, which is the State Prosecutor Selection and Disabilities Commission. So that's the same commission that appointed me, could recommend that I be removed, but would have to be for misconduct in office, persistent failure to perform the duties of my office, or conduct prejudicial to the proper administration of justice. So absent those reasons for good cause, then I would serve my term and then be removed. Obviously, there's from an accountability perspective, there are also less formal measures of accountability. If the governor or the legislature didn't like what our office was doing, I could do whatever I want with no staff and no resources, and then be left essentially on the sidewalk. There's also the fact that the legislature can also not just move from the power of the purse, but could also change the law if they did not. The legislature always has the ability to, because it's a statutory office, not a constitutional office, so that the legislature could say, okay, we only want you to do this kind of case. We'll change your statute. We don't like this. So there's always a way to tailor, shape, adjust the system moving forward from an accountability perspective. So I understand some of the arguments that, no, I am not an elected official, I'm an appointed official, but I do believe there are measures of accountability here to ensure that I discharge my current duties that I have, and if we add some scope to that. As far as the accountability, if I understand your question correctly, of the accountability and transparency of the process of the investigation, we conduct, just as we do with public official misconduct now, we conduct an investigation. We prepare a report of the findings of that investigation, as well as our recommendation, whether there should be charges, and if so, what. And we provide that to the local state's attorney in whose venue the incident occurred. And that state's attorney has 45 days to make a decision on that case, to charge that case if they do choose. And if they don't choose to charge or move forward on that case, then my office is permitted to do so. The only exception to that is if we have a case that's on a state's attorney or a member of their staff, then we can just initiate that immediately. But there's, as my esteemed colleague from Baltimore County mentioned, there's nothing that's, I believe there's nothing that stops him as the state's attorney for Baltimore County to move forward. And it's not just we're telling him we finished an investigation, we're providing investigative findings. He can conduct, or can have the local police conduct additional investigative efforts if he feels they're necessary, and then he can move to a charging decision. If we determine that there should not be, recommend no charges, that does not stop any state's attorney from overruling that decision and in their own, under their own discretion, moving forward with a charge. Sarah, did you have anything to add on that? So Sarah, David is with me here.
Just to Senator West's earlier question about whether, the state prosecutor could just decide, hey, I don't ever want to prosecute a police case. One of the reasons for removal of the state prosecutor would be a failure to engage in those duties and in the judicial processes. And so to reference that issue, the state prosecutor couldn't just say, I'm not going to engage in these cases, I'm not going to do these reports. He or she could be removed for that reason.
So, did that answer your question, Senator?
A very comprehensive answer. That was fantastic. So thank you very much.
You're welcome.
I think seeing Senator Sidnor has a question.
Thank you, Mr. Chair. And these are two questions for Chief Hyatt. One question, and Senator Chris West had asked this question of me earlier, but I think you may have a better idea. He was asking about the cost of release of certain body camera footage. Would you be able to talk about how Baltimore County goes about determining the cost of releasing body camera footage?
So I know that obviously the work that gets done, particularly in terms of redacting video, is very labor intensive. Anything as a general rule that's over 2 hours, we charge for the work for it. And obviously those costs can get significant rather quickly.
Is there an example that you may have where the public may have asked for one piece of footage and how much that may have cost?
So I'm trying to think of an example. Nothing's coming to mind. I'm sure I can follow up and think of something. One of the things that's very costly, redacting medical information, treatment, things like that. If let's say it's a police involved shooting or something like that. So there's a lot of work that goes into that. I'm not having something that comes to mind, but certainly if I can think of something after this call, I'll be happy to send it, sir.
Thank you. And just thinking about JPR 8, with regards to the Public Information Act, I'd like to read from you just a little of the county's body camera policies on page 13 under critical incidents. It reads, at the discretion of the chief of police, after consultation with the prosecuting authority, the department may publicly release BWC, body worn camera footage, within 30 business days of the incident, provided that any initial use of force investigation is completed and the required notifications have been made. And then there's a large exception paragraph that in part reads, when a non-disclosure period has been granted pursuant to an agreement with the prosecuting authority, the prosecuting authority may request in writing a 30-day extension to the department's release of critical incident BWC footage to the public. And then there's a sentence that I'm going to skip and go to the next. It says the prosecuting authority's request for an extension will be carefully considered by the department, and the final decision to release BWC footage ultimately rests with the chief of police. If the prosecuting authority seeks an additional extension or extensions, such requests should be made in the same manner for each 30-day period or until the scheduled trial date. if additional trial dates arise, an additional request for the extension will be made. The question that I had, and based off of that language, could our state's attorney continuously ask for a 30-day extension, kind of ultimately undermining the whole idea of releasing this footage earlier rather than later?
So I can see that Mr. Schellenberger wants to jump in, and I'll say before he does that, when we have incidents with body-worn camera footage, Mr. Schellenberger and I speak fairly frequently, communicate frequently about things like this. And certainly, depending on the type of case that it is, one thing that we don't want to do is impact a criminal proceeding, which could be detrimental to a case. And I know this is more of his bailiwick than mine. So if you're okay with me turning it over to him, I'll be happy to.
Oh, I'll come to him in a minute, but I'm just curious if there's a limit to these 30-day extensions, or is it something that I guess once it gets to trial, then at that point you can't ask for any more extensions? How far in the future, how many extensions can be asked for?
So the policy does not dictate that. I can tell you that since the policy has been enacted, and I can't remember the exact month that we enacted it, but it's been less than a year, we haven't had circumstances where it has been continued again, repeatedly. And the intention with putting this in the policy was based on circumstances of a case to be able to provide the latitude if it was needed to not create something that was detrimental to a criminal case, could impact a defendant in a case adversely. And we had a lot of conversation about that. There were a lot of stakeholders that were involved in the development of that policy to make sure that we were all in agreement that it was in the best interest of the policy.
So that policy, without a law in place, with the presumption that a body camera footage is going to be put out rather soon and not have a number of hurdles, this particular policy would almost eat up that idea of a body camera footage being released pretty quickly, right?
I suppose you could say something like that, but then when you look at, a terribly tragic case that we had in Baltimore County where one of our police officers was murdered. And frankly, and I'm not sure if this is something that Mr. Schellenberger is going to touch on, but had it not been for holding that footage, that would have been absolutely detrimental to that case. And that's why that language is really critical for a policy.
Thank you. Mr. Schellenberger?
So, Senator Sidnor, that policy is there to protect the defendant's right to a fair trial. In the case that Chief Hyatt just talked about, where Amy Caprio was run over by Dante Harris, we would never have been able to pick a fair jury in that case if I had released that video before that trial. That was one of the worst videos I've ever seen in my entire life. And if that video had been played over and over again on the local channels, Dante Harris would not have had a fair trial. So what that policy is there for is for your number 2 that says deprive another person of a right to a fair trial or an impartial adjudication. That policy is not there to hide anything. After the Amy Caprio body camera footage was played in that courtroom, I personally sat outside on a bench, and as every person from the TV stations and news came out, I handed them a DVD because now it was public record and the jury saw it under circumstances where the judge had approved what they were seeing. So this is being done to protect the defendant's rights. That's why that policy is there, and that's why I agreed with your number 8.
So the question then that I'd asked the chief, and I'm asking to you, how many of these extensions, will it be extension after extension until it gets to the point that there's a trial, and then after that, then the footage will be released?
Yes.
That's what I'm trying to understand.
And I can't believe that you and I have switched roles here.
Thank you very
And I
much.
see Senator Smith smiling.
Thank you. Thank you, Chairman.
Okay, great. I think seeing no more questions, thank you all very much for your time and your testimony today. This has been great. We were on the prior panel, if you could exit the Zoom room, and then we've got our next panel coming up. So we'll start off with State's Attorney Mosby, and then followed by State's Attorney Braveboy, and then we have Mr. Gibson right after that. So Madam State's Attorney, the floor is yours.
Thank you, Mr. Chairman. Thank you for the opportunity to testify specifically on JPR 10. As someone who has zealously advocated for police accountability reform, not just in our state, but throughout this country for the past 5 years, it is disheartening to have to oppose a piece of legislation that, although intended to bring about accountability, is utterly flawed. An idea that misses the mark and will interject partisan politics into whether or not police are actually held accountable in the state. The idea that passing a law that enables an independent prosecutor, as is drafted in the bill, the state prosecutor, to take advantage of police misconduct cases is simply not the solution to the police investigative independence that Americans are seeking in this time and in this moment in our country's history. I think it's fair to say that we all recognize that there is a natural sort of conflict of interest when police investigate themselves, which is inherent with any profession, which could lead to a poor investigation, delayed investigation, and ultimately whether a case is even prosecuted, which is only as good as the investigation on which it's built. But recognizing this inherent issues with any profession investigating itself, I caution this body that we cannot lose sight of the fact that police should not be investigating and policing itself. And there is definitely a desperate need for an independent investigative agency free from police conflicts of interest to work with local prosecutors on these types of cases, but there's a difference in the need for an independent investigative agency and an independent prosecutor. We cannot and should not underestimate the power of the local prosecutor elected by the will of the people of that community, not appointed to apply one standard of justice to all, regardless of race, sex, religion, and occupation. And whether you like it or not, the people of our respective jurisdictions, this is why MSA has opposed this legislation. And in my case, the people of Baltimore City elected me to apply that one standard of justice, and they trust my judgment in making a determination as to whether or not a police officer should be prosecuted. In Baltimore City, my police integrity unit is made up of prosecutors who are walled off from other prosecutors in the office. My office has secured 22 convictions of police officers since being one of the first in the country to attempt to hold police accountable for the police killing of a Black man, of Freddie Carlos Gray Jr., an innocent Black man who died in police custody in 2015. In my office, we go above and beyond to ensure transparency. In fact, my office is the only office in the entire state that provides detailed reports. And when we decide to decline to prosecute police officers, and we post that online so that the public can view. If the community that I represent is dissatisfied with my choices and my job performance, there's checks and balances that is in place that they can vote me out, as was the case in St. Louis, as was the case in Chicago, as was the case in Atlanta. This bill, which is predicated on the creation of a process that is supposedly independent, free of political concerns, and is thought to generate better police prosecutions, wholly ignores the fact that the state prosecutor is appointed by the governor. This bill wholly ignores the fact that the state prosecutor has no ties to any particular community and their only loyalty is to the party that appointed them, and relying on a politically appointed position with no ties to the particular community to carry out one standard of justice is counter to what this legislative body is attempting to do here today. Furthermore, relying on a politically appointed position with no ties to a particular community to carry out one standard of justice is when accountability becomes political. This bill even mandates the governor make the majority of appointments to a police integrity board. How does that measure up to taking into consideration? How does that not become political? And I urge these legislators today to oppose this proposal and legislation. The legitimacy of our system of justice is at issue in this country. And the moment we allow politics to define what justice looks like, what justice actually looks like, we diminish the legitimacy of our criminal justice system and hand over the keys of accountability to the governing party and not the will of the communities that local prosecutors were elected to represent. So local prosecutors are in the best position to defend the communities against corrupt police. And I only hope that you all as a legislative body will see it that way too. Thank you for your time and attention.
And thank you, State's Attorney Mosby. And obviously, you've done some innovative and great things in your office, and you've sent me some material. So I look forward to having more discussions with you in the weeks to come. So I appreciate it. Thank you.
No, thank you.
Thanks. And then next, we'll go to State's Attorney Brave Boy. We have the, I think you're on mute.
Okay, great. Thank you so much, Mr. Chair and members of the committee. For the record, I'm Aisha Braveboy, State's Attorney for Prince George's County. State's Attorney Mosby expressed so many of the sentiments that I have in my written remarks. I certainly agree that local prosecutors are in the best position to administer justice and one standard of justice, which is what we do here in Prince George's County. Everyone is held to one standard. But I did want to say that one of the things that my office does, similar to Ms. Mosby, is that we have a public integrity unit. We, in the last, I guess, 18, 19 months since I've been State's Attorney, we've indicted about 12 cases. 2 of them have gone to trial, and we've secured 2 convictions so far. We have indicted cases anywhere from second-degree murder to simple assaults. We have sex offense cases, thefts, and other types of cases. And I think having a local state's attorney that is empowered and is holding officers accountable really, I think, builds not just trust, but also it builds a system of accountability between that local police department or policing agency, if it's a sheriff's department or whatever, and that prosecutor, because the local agencies know that the prosecutor will hold them accountable, and it is a better kind of I think relationship to have. We understand that we work with them. We understand that we build cases together when we are prosecuting civilians, but they also understand it is our responsibility to hold them accountable, and that we are going to do that as well. And we've been able to do that in our county. We believe that other prosecutors throughout the state are able to exercise similar authority. One of the important things that Ms. Mosby brought up was that, the residents of my county have the ability to determine the outcome of my election. So if they don't like the decisions I'm making, if they don't believe that I'm holding individuals accountable, then they won't have me here too long. But I think what they know in my case, and in the case of several of my colleagues, is that we will be courageous. We will take on those tough cases, and we will apply one standard of justice in our respective counties. I just want to bring up one of the recent cases that I had, which was, it's a tough case. Most of these cases, especially when they involve death or serious bodily injury, very high profile. The entire community is interested in these cases. So we had a case recently where an individual did die as a result of an incident involving several officers from 3 different policing agencies within our county. After looking into that case, we presented it to a grand jury. We also hired an independent use of force expert to review the case and provide a report for us. At the end, the grand jury declined to indict in that case. And our use of force expert also indicated that the actions of those officers were justified. That report, that complete report, I released to the public. The use of force expert was on hand to provide, a summary of his report. We were also able to inform members of our community who had an interest in this case of the findings of the report. We made our use of force expert available for them to ask questions. And I think at the end of the day, people were satisfied that we had done our due diligence as I had been elected to do, and we were transparent with our public. So I think by giving prosecutors the ability to conduct independent investigations, which we were able to do. Obviously, our police department conducted their investigation, but we take their findings and we can conduct our own investigations through the use of our grand jury and other mechanisms. We were able to do that, and in this case, render a decision that was fair and just and transparent. That is the job and the work that local prosecutors put into these types of cases. We know best what our public is looking for in terms of our level of transparency and our responsibility to them. So taking that responsibility away from us or questioning that authority that we might have, I think is very problematic. What I will say, and I don't know if all my colleagues agree, what I will say is that I have no problems with a system of review. So if our office declines to prosecute a case, referring that to the appropriate body to review our decision, I have no problem with that, because I think that there should be certainly accountability. And if the public is concerned about a decision that our office has made, and if there's an opportunity for another agency to review it, I personally don't have a problem with that. But what I wouldn't want is for my office not to have the first bite at the apple, because that's what I was elected to do. So I'm happy to work with you on your proposal to try to address some of the issues that I know are important, because we are a part of the national conversation as well. So we understand the conversations that are going on, the concerns around prosecutors and police departments. So I'm not immune to that. I'm not going to pretend that that's not a part of the national conversation and it shouldn't be discussed here locally. But I think there are solutions rather than having an independent agency reviewing these types of cases. I think there's a process that we can have in this state that would still give the local prosecutors the authority and the responsibility to prosecute and hold officers accountable for misconduct. So thank you very much, and I'm happy to answer any questions you might have.
Okay, thank you very much. And obviously I'll be in touch with everyone here as we move forward. So appreciate that. Mr. Gibson, I see the mask behind you. Is that, it looks like the Constitution or the constellation? It's a very stately background.
But close. Thank you, Chairman Smith, and I appreciate everyone's time today. I'll try to be succinct. Today I'm offering my testimony related to JPR 9 and JPR 11. JPR 9 deals with police officer testimony, presumption of inadmissibility. JPR 11 deals with torts claims, limits, and liability, qualified immunity for law enforcement officers. In regard to JPR 9, I'd ask that you give this bill an unfavorable report and not support it. I agree that we want to encourage officers to activate their body-worn camera in a timely manner. However, to completely bar their testimony over procedural or administrative error for failing to turn on the body-worn camera is a bridge too far. Just because something is not recorded, even though recording technology is available, doesn't mean that event didn't happen. Moreover, every juror selected for a jury trial in Maryland is asked the question, would you give more or less weight to the testimony of an officer simply because they're an officer? When asked this question, jurors, if they respond yes, are disqualified from service. Why? Because they are biased and they've expressed the bias. Via the proposed rule, you're throwing that voir dire question on its head, because under the proposed rule, if a civilian were to see the same thing that an officer were to see, they don't need video in order to provide that information to the fact finder, to the jury, to the court. If this bill passed, it would create a class of people with less credibility simply due to their employment. Yet we trust those same people, the law enforcement officers, to protect and serve us. If an officer's testimony is reasonable, and certainly if it's corroborated by other evidence, it should not be barred simply because of an error in turning on the body-worn camera. That is a fact which a jury can weigh as to the credibility of the officer. And I guess I'd pose a question, which would be, if the only witness to a shooting was an officer who didn't have their body-worn camera on, but had body-worn camera on their person, and they're the only person who saw the shooting happen, are we comfortable as a society letting that shooter go because of an administrative error, because they didn't turn on the body-worn in time? Like, are we comfortable with keeping that person in society are we safer as a result of that kind of thought? Again, this is a credibility issue and one which juries should decide. It should not be decided by the legislature. As to JPR 11, which deals with tort claims, limits, and liability, qualified immunity. Qualified immunity is the concept that certain individuals, based upon their employment, it applies to the legislature, it applies to prosecutors, it applies to police, cannot be found civilly liable for their errors if their errors occurred, or for their actions rather, if their actions occurred during the scope or within the scope of their duties, of their work-related duties. So by way of example, if the legislature passed a bill saying that alcohol cannot be sold after 5 p.m. on Mondays, the alcohol distributors, the bars, the restaurants that profit from alcohol being sold after 5 p.m. on Mondays couldn't turn around and sue you for passing that bill, right? You have that protection. In the police setting, and well, before I get to that, if you think about it this way, if qualified immunity was removed from the legislature, what effect would it have on you? You probably wouldn't pass many bills because you want to make sure you can pay for your kid's school, you want to pay for your kid's house, you don't want to be sued. It would also deter people from running for office because they don't want to be exposed that way. It would create a chilling effect. Applied in a law enforcement context, if an officer sees a person walking down the street and they've got a pendulous bulge in their coat that's swinging and looks like a gun, right? It looks like it's the shape of a gun. We as a society want that officer to engage that individual, to stop them, to talk to them, to make sure that everything's fine. Maybe it is, and they go about their business. If it isn't, they potentially have saved a life, right? And so we don't want officers to avoid the interaction simply because they're worried about a financial consequence to themselves. And that's exactly what this bill would do. So I urge you to avoid that horrific consequence for society and to give an unfavorable report to JPR 11. And I'm perfectly willing to have discussions further if anyone wants to reach out to me and talk further about either of these issues or any issues related to criminal justice. Thank you for your time.
Okay, excellent. Thank you very much. So for the state's attorneys, I don't, what we're going to do, just because it's a kind of a, with the state's attorneys, and then we're going to go to some more general testimony. If folks have questions now for the state's attorneys, I'd like to just do that now. So then I know that they've got important work to attend to. So Senator Heddleman.
Thank you, Mr. Chairman. And I have two questions. One is for State's Attorney Braveboy. She mentioned that she is not adverse to a review. And I guess I would ask who in your mind then would be an acceptable entity to do that sort of outside review. And what I also don't understand is where do you see in JPR 10 that your authority is, you said you wanted the bite at the apple. And I guess as I see it, you're still very much eating the apple in this.
Yeah, I think there's one part of the bill, and I'm sorry I don't have the bill in front of me, that I think if the case, I think a case can be referred to the Office of the State Prosecutor. I can't remember that part of the bill, but there's one part that I think would question whether or not we would originally, like if we wanted to take the case, if we could, if it ended up being referred by, like, let's say the Office of the Attorney General or something like that. But I'll take a look at it and point out that section. It didn't seem to be consistent with what the rest of the bill was intending to do. But anyway, I think that in terms of a reviewing agency, I mean, I think that the best agency probably would be the Office of the Attorney General. That's what I would recommend. The Office of the Attorney General could refer it to the U.S. Attorney's Office or some other agency, but I would say that the Office of the Attorney General would probably be the most appropriate agency to review it.
Okay, thank you. And a follow-up, I guess, for State's Attorney Gibson. I'm curious as to why you did not have any comments on JPR 10, and as a state's attorney, and also as somebody who has this MOU with another county. and has not, obviously it's not close to being the same, but sort of has engaged in having outside reviews and investigations.
Thank you, Senator Hedelman. So I remain silent on that issue. I was the chair, just as a way of procedural history, I was the chair of our Committee for Prosecutorial and Police Reforms for the MSAA. We got together and met on several occasions, and all the prosecutors got together. We agreed reforms are necessary. We agreed changes are necessary. And we're trying to come up with solutions that we thought would be reasonable, maintain safety, and give greater peace of mind to the community related to criminal justice. And we came up with 12 recommendations. One of those recommendations was that, oh, strike that. Before I get to what they were, all 12 recommendations were bipartisan. All 12 recommendations, they were not all unanimous, but they were all supported by the majority of the prosecutors across the state. One of those recommendations that I didn't personally vote for, but being that I was the person who was the president of that particular committee, I supported, was that each prosecutor have the right to define for themselves the prosecution of the cases. So no divestment of prosecutorial authority related to the investigation of any case, and in particular police involved cases. Now, I personally have obviously taken a different position because I delegate that portion of my authority to John McCarthy, my counterpart in Montgomery County, and he delegates that portion of authority to myself. But in light of the fact that that position was the minority position, not supported by the majority of the prosecutors in the state when we voted, I chose not to speak on the issue because I was the president of that committee.
Okay,
And if I could, Senator, if I could just address a question really quickly.
Second, I have a follow-up. One second. If you can, would it be possible for you to share those 12 recommendations around which there was consensus with the committee?
Absolutely. I shared with Delegate Atterbury, and so they had a copy. I will absolutely make sure, Chairman Smith, if I can send it to you, and then you can distribute it to the committee. Would that be helpful? Because I won't get that done today. Absolutely.
Thank you.
And thank you.
Senator Hedelman, are you wrapped up? Are you?
I'm fine unless State's Attorney would like to comment.
Senator, I just wanted to address your concern.
We got you.
I wanted to address your concern that you asked about State's Attorney Braveboy when you were asking about the proposal for the legislative bill 10. One of the things that we have to understand and recognize is that this bill is proposing concurrent jurisdiction over these types of cases that they did not necessarily have in the first place. And I think that that is a dangerous sort of precedence that we are setting, right? Allowing the state prosecutor, which is an appointed position, to be able to delve into these types of cases, as opposed to what is being proposed by State Attorney Braveboy, which is, hey, if you want a checks and balances, the first sort of association, the first bite at the apple should remain within the jurisdiction of the local prosecutor and the will of the people to make a determination. And if in fact we decline to prosecute, if you want an additional hurdle of some sort of checks and balances, we can pass that off to the state prosecutor or the attorney general. Is totally different than giving them that first bite at the apple, and that the bill provides that concurrent jurisdiction. So I think that's the distinction.
I appreciate that, but she did mention that the attorney general, which is different from what you're saying, but thank you.
It's attorney general or the state prosecutor is, I believe, what she said.
Okay, great. I think no more questions for the state's attorneys. I want to, actually we do, sorry, we have Senator Sidnor.
Thank you. My first question is to State's Attorney Mosby. You mentioned a number of areas where your department reports, essentially you report out on a variety of statistics. I can remember last session there being some discussion around your reporting and numbers and things like that. But just in my going to a variety of websites, it seems you're one of the few offices that attempts to provide some sort of transparency with regard to what your office is doing. And I wanted you to confirm something. I haven't been able to find anything on record that says that state's attorneys have to report out to what they're doing. Am I correct in that?
So I can tell you, just based off of our own research, one of the things that we attempted to do was to be in line with the Association of Prosecuting Attorneys and 21st Century Principles of Prosecution. And one of the things that we attempt to do in an effort to be transparent is to provide all of our police declinations pertaining to use of force and injuries, serious bodily injuries, pertaining to police officers. We put that information online, and we give an account and a rationale and justification on our website so that the media and so that the public can see exactly why we are declining to charge in a particular case. And I think that that's important for in ensuring that level of trust and transparency, which is needed around these types of issues. But we do get into a very sort of dangerous precedence when we have an expectation, as is being proposed by this bill, that board would be comprised of, gubernatorial appointees, or that independent prosecutor is an individual who's appointed by a political party. And so I just get very leery. Yes, we've been able to set a precedence in the state of Maryland, which I hope, will be a model for the rest of the country. And I do believe that we are, but at the end of the day, although well-intentioned, I don't think that this bill brings us to where we want to be. And so I just get nervous, and that's the reason why I felt it so incredibly important for me to come here and to testify orally.
Right. Now,
can I just respond to Senator Hedelman's question, because I did find that part of the bill that I think was just a little inconsistent with maybe what the intent was. But on page 11, I guess, of our packet, and it has it expands the state prosecutor's authority. And if you look at the bottom of page 11, it says any criminal offense committed by an officer while in performance of the police officer's official duties, if requested by the state's attorney of the jurisdiction or the attorney general. So that's where I found that's a little inconsistent with what I thought the intent of the bill was. So,
but if I might stick with my line of questioning, State's Attorney Braveboy, does your office report out certain statistics and things to bring transparency to your office?
We do. I mean, obviously, we haven't been in office as long, but we certainly do provide information to our public. And in fact, as I indicated before, when we actually were able to get a pretty extensive report related to a police-involved shooting, we made not only the report public, but our use of force expert available to the public so that he could answer questions. But we do intend to continue to grow our website. Right now, we're kind of rebuilding our website so that we can provide more information. Currently, the website is just not designed for that. So we're kind of breaking away from the county's web-based platform, and so that we can have a more expansive database. Or
State's Attorney Gibson?
Yes, we do not. I think you have to be very, very careful about stats, because stats cause you to chase particular outcomes. Our mission is to pursue justice, and justice might be reflected by letting someone go, which looks like a null pros, which to some might be a bad thing, right? Or maybe counted as a negative, whereas in fact it's a positive. So like stats, cold stats by themselves can be misinterpreted, and furthermore, cold stats by themselves create incentives to chase particular outcomes, particular narratives.
But if the state's attorney's office is providing a narrative with those stats and giving an explanation, I mean, it could be a good thing, bringing transparency to what your offices are doing. I mean, really, when you think about it, the state's attorneys are some of the most powerful people within this entire system. And as I've said, we focus so much on police officers that sometimes we forget what you all do.
I agree that we're a very powerful entity in terms of justice in the community. And I agree that we deeply impact justice in our relative communities without question. My only point is that stats alone, and even it would be an explanation per stat. So stats, it would be a treatise. Stats alone don't tell the tale, and you have to avoid. I don't reward my prosecutors for getting guilties. I just reward them for pursuing justice, right? I want them to let someone go if they find evidence that they didn't do the crime. I want them to pursue someone with all of their passion and all their might and all their vigor if they believe that they are in fact guilty of the crime. And a cold number of case number X equals this, it can lead to distortions, which can lead to negative results, and in fact can create the very problems we're trying to avoid right now.
Now, you were speaking about with JPR 9.
Yes, sir.
I guess the penalty of throwing out essentially the evidence and letting somebody go free. So I mean, I guess essentially it's akin to the doctrine of the fruit of the poisonous tree, where if law enforcement, or if the state isn't doing its job, the penalty essentially is to stop that information from coming in. Is that probably?
No, I don't think that analogy is not it's not analogous, right? So in this instance, you've created two classes of people, right? There are a civilian sees an offense occur. There's no requirement that person have any extra corroboration to support their testimony. They are allowed to testify to whatever they say they saw. A police officer with a body-worn camera unit that's not on, you're creating a separate standard for which they would be allowed to testify. And you're saying, if you had your body-worn camera, and if it wasn't activated under these particular circumstances, you can't testify, right? That is, quite frankly, dangerous. And two, again, it runs counter to the very process of trying to find a fair and unbiased, a fair and unbiased process for determining guilt or innocence, of determining what actually happened. Jurors, the 12 citizens in the box, can decide, and defense counsel will certainly point out, and the state will probably raise in their case in chief, officer, you didn't have your body-worn camera on, didn't you? Defense is certainly going to bring that up. And the jury, those 12 individuals, can listen to the evidence and decide, I don't believe the officer, or I do believe the officer. But what you're doing is instead creating a litmus test saying, because you're a police officer and you didn't meet this criteria, you're automatically disqualified. And that is incredibly problematic.
And Senator, if I could just add one point to Senator, if I could just add one point to your question,
Yes.
With reference to that bill, right? If you have an officer who does not, who intentionally does not put on his body-worn camera footage because he doesn't want to be depicted, and then ultimately it's inadmissible because he has not put it on, that counts against and cuts against the prosecution of that officer. Right? Like, we don't want to put ourselves in a position where we're emboldening corrupt police officers. So those individuals that are intentionally doing and performing those acts. And so that's what we have to be careful with reference to that bill.
So the follow-up question is, how do your offices deal with these officers who have done these types of intentional acts to stop the use of the body-worn cameras? They haven't turned them on. How do you all deal with them?
So one of the things that I can point to, Senator, is that, you know, with the full implementation of body-worn cameras and all officers following the untimely death of Freddie Gray, we know that accountability led to exposure. A week after I charged those officers, the Department of Justice came in and exposed the discriminatory policing practices of the 8th largest police department in the country. That exposure ultimately led to reform. We now have a federally enforceable consent decree. And because of a lot of those decisions, we have the full implementation of body-worn camera on officers, where we had officers who were actually reenacting the discovery and seizure of evidence and not placing that into their statement of probable cause. And one of the things that I came out, despite the, you know, the contention among me and then I've worked with 5 police commissioners. I think that was the 3rd police commissioner at that point. There was contention, and that he said I was making the wrong call. And what I said quite candidly was that if you fail to put into your statement of probable cause that you reenacted a scene, then it goes to your credibility. And guess what? We're not prosecuting your cases. We're not going to be defending you because it calls into question your credibility. And so these are all issues that are at play. And when you say, what is the solution? Again, we're not having and running into that problem in the city of Baltimore anymore, right? Like it's very clear. Officers know that you cannot reenact the discovery and seizure of evidence and not place it in your statement of probable cause. It goes back to the point that I made in the very beginning, is that you cannot underestimate the power of the local prosecutor to utilize and implement that discretion in a way that's going to ensure that cultural sort of shift in any sort of police departments. We now have use of force policies. We have de-escalation policies. We have affirmative duties to intervene when your fellow officers cross the line. And a lot of that has to do with the local discretion of local prosecutors, which is one of the reasons why I'm here saying, please do not diminish the power of the local prosecutor to do our jobs.
Thank you.
In Howard County, to answer your question, Senator Sidmore, in Howard County, we don't have body-worn camera. But I and this was unanimous for the recommendations that we had. All the prosecutors across the state agreed that body-worn camera is a good thing. However, it's an expensive thing, and there are costs associated with our offices that are often not considered. So body-worn camera is examined from a police perspective, but we have to do, body-worn camera does not increase our caseloads much. I mean, yes, we might charge a couple more officers. We have more evidence of their criminality. But what it does do beyond the caseloads, it exponentially increases our workloads. So we have Brady obligations. We can turn over information that shows that a person did the crime that we want to use at court. We can turn over any information that exonerates the defendant, that we have unique control over, right? And so for each case, you now have an exponential increase in workload because you have to review all that video, screen all that video, redact video if there's anything that is inappropriate to send out, right? And then transmit that video. And then we have storage requirements, and we have to display the video at trial. And then we have to store the information for the required period of time. In Howard County, we follow a circuit court schedule. So for any case that has a 20-year or more sentence, we retain that information, retain all the discovery related to that into perpetuity. For any case with 20 years or less, it's 20 years after the last post-conviction event. So you can see that storing high-def video from every officer that came on the scene, plus all the paperwork that we had prior to body-worn technology, it becomes expensive rapidly. And so we are very much in favor of body-worn camera. I think it's a great tool. It's not a panacea. It's not perfect, but it is a phenomenal tool for giving peace of mind to the community, to improving trust, and and giving us tools to hold people accountable. We just need the funds in order to make it work.
I serve on a body-worn camera task force that's looking at cost, and I don't think we've actually reached out to state's attorneys or considered that you all had cost in this. I'll be sure to report that back to our chair, and we may be reaching out to you all. Thank you.
And please do, Senator. We have a whole unit that is dedicated in the city of Baltimore, a body-worn camera division with several attorneys and law clerks that review this type of information on a daily basis, provide the redactions for our attorneys, flag it for our attorneys. Please reach out to our office, and we would love to work with you all in the implementation of it statewide, because I think that it's critical. It has increased our caseload. Let me just tell you, we've prosecuted a number of officers just in the recent years as a direct result of the body-worn cameras, which actually depicted on the camera as opposed to what's been being written in statements of probable cause. And so we are here to assist in any way that we can.
Again, thank you all very much. Thank you, Mr. Chair.
All right, thank you. This has been very, very helpful. So it looks like there are no more questions for our state's attorneys. So if you all feel like you want to hang around, you're welcome to do so. But if not, I know you've got a lot of service to do to our community. So thank you all for what you do, and thank you for being here. We'll be in touch.
Thank you very much. Have a good day.
Great. Okay, now we'll move on to Miss Willis, Greta Willis.
Hi, good afternoon. My name is Greta Willis. Again, I am the mother of Kevin L. Cooper and the co-founder and president of the Kevin L. Cooper Foundation, created in my son's name. Thank you again for giving me an opportunity to speak today in regards to this important issue regarding JPR 12, law enforcement drug testing. After my 14-year-old son was shot and killed by the inexperienced Baltimore City police officer with 1 year on the force, and on Saturday, August the 12th of 2006, by experiencing a mental health crisis, I was never given an opportunity to accompany my son to the hospital. 2 detectives escorted me to the police station to make a statement. Then they said that I would be allowed to go to see my son, in which I was informed at that time that my son was alive and doing well. After hours at the Baltimore City Police Headquarters, I was driven to the hospital and learned of the fatal gunshot wound that entered through my son's shoulder and burst his heart. I was in total shock and disbelief. My son's body was held for police investigation. During this time, a toxicology screen was performed on the deceased, in which all test results were negative. So we know his results were negative, but the police officer was not given a drug toxicology screen. So we don't know what his status or his state of mind was at 9:30 a.m. in the morning. If victims are not given a choice to consent to a toxicology screen, after any major incident, law enforcement officers should be required to submit to a toxicology screening. This will reduce the unfortunate loss of life for our unarmed family members, as well as determining the status of the officer. Any state employee involved in a regular car accident is subject to a toxicology screen by their employer. This should hold the same for law enforcement officers who is held at a higher standard. This should be mandatory. Mandatory toxicology screens after any major incident. May it be shooting, arrest, there's some injuries, bodily injuries or cause, they should have a toxicology screen on a mandatory basis. I urge this committee to vote and make changes. Thank you again for your time and your consideration that all families will be able to go home as well, safe back unto their family members. Thank you.
Thank you, Ms. Willis, and it's good to see you again. And as always, thank you. Next, we have Jean. You can help a brother out with the pronunciation of your last name.
I should have written it phonetically. It's Zaharia-Shevitz. But you can call me Jean Z, because that's what everybody calls me.
Zaharia-Shevitz. Thank you.
Thank you. Good afternoon, and thank you for the opportunity to speak with you today. My name is Jean Zaharia-Shevitz. I'm a litigator with the Baltimore firm of Brown, Goldstein, and Levy, and I'm here to speak about JPR 11. Just to clear something up, I think State's Attorney Gibson was wrong that this bill deals with qualified immunity. It only deals with the caps on the tort claims, both local and state. I wish we were getting rid of qualified immunity and we could have a spirited debate about that and whether it's a good or bad thing for people in this country. And maybe we can do that later in session or next year. But that's not, I think that's a bit of a boogeyman for this bill. It's really just about the claims caps. I and many of my colleagues feel that the current caps are way too low to incentivize any kind of change. And if that's what we're doing with these police reform bills, then we need to keep that in mind. It's a drop in the bucket compared to government budgets. It means that compensation often doesn't even cover the cost of the actual economic costs victims incur, medical bills, lost wages, if they're lucky enough to survive, much less deal with the emotional trauma and harm that they and their families suffer. And that's in a different bucket. So we're only talking about lifting the caps on economic damages here. I think the current situation also pushes lawyers like myself to simply bring claims in federal court. So when you go to federal court, there are no damages caps, which is a much worse situation for the state if we win. But there's also the huge hurdle of federal qualified immunity, which means that it's harder to get justice for victims. And I think everybody is better served if there is an avenue to bring state claims in state court where there's fair compensation. It's not breaking anyone's bank, but it's incentivizing change so that down the line, there will be fewer victims. I would love to be put out of work by not having to bring civil rights claims anymore. But unfortunately, it happens all too often in our society, as we all know these days. I don't think ultimately this bill goes far enough, as I'm sure you would expect someone like me to say, because as per my reading, the state is still immune if a law enforcement officer acts with gross negligence or malice, which is what has made everybody so upset about killings like George Floyd and the shooting of Jacob Blake. Those officers there might be the normal caps for them, or they wouldn't even be suable. And but I do think it's ultimately an improvement over the current state of affairs. If we're truly committed to reforming policing in Maryland and honoring the values enshrined in our Declaration of Rights, then I think we have to begin with reforming our laws. And these modest changes to the Tort Claims Act's caps are a step in that direction. So I urge you to move forward with JPR 11. And again, thank you for your time this afternoon.
Thank you very much for clarifying the qualified immunity. It's certainly not part of the bill, and I had a note here to correct Mr. Gibson on that. So I had a good conversation with Mr. Tolley about that, though, but it's not in this bill. And I know that Senator Booker and Senator Van Hollen are working on some qualified immunity language, some 1983 language at the federal level, but given the state of the Supreme Court, we'll see how that interpretation changes, or if that, if we get the Senate, we'll see. But
we're all learning not to pin all of our hopes on the Supreme Court. So whatever you can do is great for those of us practicing in Maryland, and we thank you.
Understood. Well, thank you very much. Next, we will have Mr. Montgomery. Good to see you again. I'll unmute you.
Thank you. I introduced myself yesterday, so I'll simply move to offering comments on several bills. First, I'd like to speak about Bill 10. Giving the state prosecutor authority to investigate and prosecute alleged crimes against police officers is unnecessary and questionably constitutional. I agree with the state's attorneys who pointed this out. State prosecutor is appointed by and only answers to the governor. The elected sheriffs and state's attorneys now investigate and review and decide whether to prosecute accusations of crimes by police officers. To me, what's important is, since I'm one of the voters, they are entrusted by us with those tasks. My sheriff has told me that when he was in the state police, he was frequently asked by chiefs or officers to investigate use of force in their jurisdictions. Bill 10 would set up a new police unit in the Office of the State Prosecutor. He and I think that would be duplicative and not likely to improve the quality of investigations. Investigation should be left to the professionals. In my view, Bill 10 adds nothing but a risk of less competent investigation and politically motivated interference. I admit the ban on accepting free military equipment is a pet peeve of mine. I've talked about it many times in the last few days with police officers. All it would do is put more pressure on public safety budgets that are already inadequate. I've learned from both Easton PD and the Talbot County Sheriff that they want an armored vehicle. We too have barricaded criminals and hostages on the Eastern Shore. They can buy it for about $100,000, or they can get it free from military surplus. They can purchase just about every item on your list, from civilian suppliers to law enforcement. Decisions about whether to acquire such equipment should be made by the elected officials in each jurisdiction. If the legislature wants to force local governments to pay for equipment rather than get it for free, then you could at least reimburse local jurisdictions for the unfunded mandate that this imposes. My sheriff has also commented that no-knock warrants could well be safer for everyone than announced ones because they are served by teams trained in safe methods of entry. He recommends the legislature commission a fact-based study to find out one way or another which is in fact safer before banning them, not just relying on a few anecdotes. Finally, I thought Mr. Gibson states the case for qualified immunity very well. I'm out of time, but let me just point out that I fear that the consequences of qualified immunity would even be far worse if Bill 1 was passed, because those unrealistic standards would put police in the position of being sued in civil suits against which they would have no protection, even more likely. Thank you.
Thank you, Mr. Montgomery. Thank you very much. Next, we'll move on to Mr. Boston. Frank, you're up.
Can you hear me?
Yes, sir.
Good afternoon, Mr. Chairman and members of the committee. I am Frank Boston III, and I am the legislative attorney for the Maryland State Fraternal Order of Police, representing over 20,000 officers throughout the state. We would like to thank this committee for taking time to study the perceived challenges facing police practices and procedures in Maryland. We are optimistic that when you complete this deep dive into this space, you will conclude that law enforcement officers and agencies throughout the state have done a great job trying to do the right thing. Are there some tweaks that need to be made? I'm sure there are. But by and large, Maryland has good laws on the books already. To this end, the Maryland FOP is here to be a resource on how these proposed laws will affect the actual practice of everyday policing. Thank you for giving us a seat at the table. We look forward to working with this committee. And again, thanks for putting the time in and taking this issue up early. So hopefully we can have smooth hearings and justifiable bills later in the session. Thank you.
Thank you very much, Mr. Boston. Sentiments mutual. So looking forward to working with you. Ms. Smith. Yeah. Kaya. She was just here. Ms. Smith, you are up next.
Okay, can you guys hear me now? Hello?
Yes, we can hear you loud and clear.
Okay, great, I'm sorry. On March 9th, 2012, I was beaten. I was abused by officers of the Baltimore City Police Department. Sadly, the system continued to abuse me after that date. And while they beat me, I fought against the system, and 5 years later was able to get a small sense of justice against those responsible for how I was treated. On that horrible day, my 2-year-old daughter and I were driving home. As I was driving on Harford Road, traffic came to a standstill. I looked to my right and I saw a group of officers in a circle facing out. I then realized that in the center of the circle was an officer on the ground with his knee pressed against a young boy's head. I realized that the other officers were just standing guard to prevent the other students who had just gotten out of school from stopping the main officer from hurting their friend. As traffic was stopped, I turned my car off, got out, lifted my cell phone, and started recording when an officer charged towards me like the Incredible Hulk, yelling something in the nature of, "You want to record something? Record this, B." I tried to get back into my car. He pried the door open, grabbed me by my hair, dragged me out of my car by my hair. By the time he yanked me out of the car, 3 officers were right behind him and joined him in slamming me into my car, grabbing my cell phone, destroying it, beating me, and they threw me to the hood of my car. While I laid there, I saw my daughter. Can you guys see me?
You're
As
back.
I laid-
We could always
Okay.
hear you, but you're back up.
I'm sorry. As I laid there, I saw my daughter hysterically crying. I asked the main officer, would it be okay that he called my mom so that she wouldn't be there when I get arrested? He said, no, Child Protective Services will be here to pick up your daughter. It wasn't enough that he had beat me and stripped me of my human rights. He now wanted to terrorize a baby. Continuously, I see a pattern of non-compassion for human beings, a sociopath with no compassion for a baby, a sociopath who holds his knee on someone's neck while they say, I can't breathe. A sociopath who kills an unarmed man in front of his children, and the list goes on and on. They charged me with assaulting the 4 officers. These charges required me to hire a lawyer, take time from work, and be embarrassed in my community, all for trying to help the police stop violating a little boy's right. But the system failures didn't end there. We filed a suit against the police, and they, through their panel of lawyers, victimized me again. They removed all the people of color from the jury, and the judge allowed it. But the worst is during the trial, one of the defense attorneys said words that were racist and meant to embarrass me. We lost, but the attorney continued to fight, and we won the appeal. While we won, the system failed. It failed me and others and who are victims of abuse, victims of police misconduct, victims of system failures. I hope this committee understands the importance of this problem, not just for women or men who look like me, but for everyone that lives in Maryland. I did nothing wrong, but this has changed my life forever. Thank you.
Ms. Smith, thank you for taking the time to testify and share your story. Obviously, it takes courage to do that, and I appreciate it. So thank you for your testimony today.
Thank you so much. And just one other thing, the saddest thing was that he knew he was protected by a broken system. I told him that I was going to contact the Internal Affairs, and he looked me in my eye and said, call them. So this is the behavior and the attitude of the police towards your citizens. But thank you very much.
Thank you. Okay, next we'll have Mr. Hoffman. That's right, unmute you. There you go.
Thank you, Mr. Chairman, members of the committee. My name is Josh Hoffman. I'm a defense attorney working mostly in Baltimore County, and some of you might remember me from my time as a staffer in the General Assembly there. On that note, thank you, Senator Sidnor. I'm here to support JPR 9. Don't be discouraged. You are on the right track, and I'm going to stay in contact with you about this. I've been hearing a lot of opposition to it based on misunderstandings of the bill and fantasies and other things. But there's at least one amendment that needs to be added, in my opinion. As it's worded, this bill covers the activation of the body cameras, but it also needs to cover what happens after. In other words, what happens to the footage after it's been recorded. As Mr. Gibbons says, it's an important tool, but it can also be a weapon for the prosecution. On the defense side, we don't get to decide if it's activated or if it's edited. We have to work with what we're given. I'll give you a quick example. Just from this month, the other day, I met with a client who was charged with, among other things, assaulting the police. And he told me, of course, that he didn't assault the police, that he ran from the police, and then they just beat the brakes off of him. And the last part is indisputable. He was hospitalized and he was savagely beaten. So I went to the body-worn camera footage to find out the truth, of course, and it was provided to me on evidence.com, but it began in the middle of this tussle. So I have 2 camera angles from 2 officers that begin about a minute from when he is handcuffed. And it's the middle of them wrestling around on the ground. Now, I know the protocols for Baltimore County. These cameras don't turn on automatically in the middle of a wrestling match, and these officers certainly were not reaching up to turn it on at that time. So what happened after that? What happened to the footage? Was it edited by somebody on the state's attorney's office, on evidence.com, at the police department? I'm told that if you upload a video on evidence.com, you can edit the time, you can edit the brightness, you can edit the contrast. We heard Mr. Schellenberger mention redactions moments ago. So were the Brady materials covered up? Now, I suggest that the bill be amended to cover this type of situation by adding in section C, after the part about knowing and willful failure to activate the camera in violation of departmental policy, adding the language, or if it is activated and a material portion of the footage is unavailable, the same presumption of inadmissibility applies, and subject to the same exceptions in subsection 2 there. And we would define a material portion as being the subject of the criminal prosecution in question. And no, fighting it in court each and every instance is not the best solution for very practical reasons that I don't have the time to go into right now, but I would love to. One is people might just throw up their hands and say, we don't have the footage. Another is that being held pretrial, as the client in question that I'm talking about here is, tends to deprive people of their ability and the means to fight and have an effective defense because it takes time they're sitting in jail. And as Mr. Frazier says, the missing evidence instruction is great, but it is no substitute for the truth. It needs to be a bright line rule with the appropriate exceptions as laid out in the bill are similar. And we all know that because the abuses are widespread. That's why we're here in the first place. Thank you all so much for your time. I hope to be in contact with all of you in the coming months.
Thank you, Mr. Hoffman. And yeah, always welcome back into the MGA. All right, Mr. Greenberg is next.
Thank you, Chairman. On December 18, 2014, Daquan Wallace was a healthy young 20-year-old black male. On that date, he was severely beaten and his civil rights were violated. He was in a coma, he had a tracheostomy. He's now 26 years old, but he's still suffering from a catastrophic traumatic brain injury, leaving him with amnesia and cognitive impairment. Due to his injuries, his family, they're required to care for him 24/7. He lives, but not the life he ever expected or wants, not the life his family wanted for him or for them. He incurred close to $500,000 in medical bills, surgery, neurologist, therapist, and other medical expenses. He also can never work, a life of being unable to provide for himself or others. JPR 11 addresses a horrific problem with this system. The cap, which prior to October 1st, 2015, was only $200,000. If the cap applies to the Wallace case, or for that matter, any other case, it wouldn't even pay for half of his medical expenses. Therefore, meaningful justice will never occur for Daquan Wallace or his family if the cap applies. Maryland Association for Justice supports a change in JPR 11, and if you have any questions, both I and other members will gladly help. Thank you.
Thank you very much. Next, we will have Mr. Winkleman.
Good afternoon, Mr. Chairman, members of the committee. Thank you for allowing me to testify today. I am a civil rights attorney in Prince George's County, and I'm speaking in support of JPR 11. A few of my predecessors have spoken of the fairness that this brings to the system in helping the most grievously injured. So if I may, for a few moments, Mr. Chairman, speak to the other issue, and that is what you discussed at the beginning of the hearings today, how JPR 11 can also incentivize change. When the departments and the local jurisdictions have the economic incentive to make a change, hopefully they'll be more interested in making the change and preventing police brutality. For the last 50, 100 plus years, I think we can all agree that police brutality remains a problem in this country. We have tried all the other remedies that we have available to us. We have changed laws. The change in laws have failed to incentivize the change necessary. You can also rely on the altruism of the governments and the officers involved. That has failed as well. So the last classic example of how to incentivize change of any industry is through money. And it is fairness, but it is also that incentivization that you talked about at the beginning, Mr. Chairman, and why it is so important to have this provision changed in the law. So I would ask that you adopt JPR 11 for that reason. Another thing, if I may, Mr. Chairman, is point out this. There have been concerns earlier in the day from individuals from Carroll County, Eastern Shore, Frederick, that it would bankrupt them or hurt their jurisdictions in some way. In addition to what Mr. Hansel said earlier, that they're covered by insurance, just as I am when I drive home, they're covered by insurance. But much more importantly, I would like the committee to understand, I've been practicing this type of law for more than 20 years. I am not familiar with a single police misconduct verdict in Carroll County or the Eastern Shore or Frederick where this bill would have had any operation whatsoever. The closest you can get is the Saylor case in Frederick, And that case was the young man with Down syndrome in the movie theater. And that case involved absolutely no economic damages. It was all non-economic damages. So this bill would have no effect on that. So what I would suggest to the committee is that those concerns are not legitimate concerns. Thank you, Mr. Chairman.
Thank you for clearing that up. And Senator West will have questions at the end. If that's, gotcha. I've got your question noted. Okay, Mr. Rhodes, James Rhodes.
Good afternoon, Chairman, committee members. Thank you for allowing me the opportunity to speak here today. I'm also a civil rights attorney. I practice primarily in Baltimore City and Baltimore County, and I would like to address JPR 11 more from a practical standpoint. As the current maximum stand, you basically are giving discounts for the sole purpose of being a government employee. Police officers, for instance, get allegations from anything from false arrests, sex assaults to wrongful death. And if you actually consider in the criminal arena that a person committing, say, a rape or a murder can actually go to jail for the exact same amount of time, which is life, that's because regardless of whether a person is killed or suffered from that sexual assault, there are lasting injuries on both the surviving victim and or family members of that victim. Injuries at the hands of government employees have just as long of an effect, primarily because of the trust we placed in them. When you go to trials where you see doctors, lawyers, or other civilians charged with criminal offenses, even government employees, they generally suffer the exact same punishment. But what we do know is that the maximum for those punishments don't change because people wear a certain uniform. The same applies to those government employees when they're in their civilian capacity. Currently, we have about 50% less value placed on the injuries to civilians when the person is simply in a government uniform. Not that they hold any more significant than a civilian, but simply based on that position. And I think JPR 11 simply attempts to bring some equity, a less amount of equity, but some equity to this situation. So if you consider, in my opinion, that you can't be a police officer and go in your civilian vehicle, cause an accident, and claim that simply because you're a police officer, you should get a discount. The same should apply to when you are in your government capacity causing an injury to civilians. So I'm here to support JPR 11 because it goes a long way to start some of the process, at least, of bringing some equality to the amount of value placed on injuries to civilians at the hands of government employees. So I implore you all to consider that bill and consider the fact that for something not necessarily as strong as death, I represented an employee at the Department of Defense who was wrongfully charged by a police officer. Even though that employee was acquitted and able to sue afterwards, the documentation from that charge remained in his file permanently, which means that when it comes time for his evaluations, raises, everything compared to other employees who didn't get charged, that document stays in his file. So consider that civilians have long-lasting consequences from wrongful police actions that are also extremely financially related. I ask for your consideration with respect to that bill. Thank you.
Thank you very much, Mr. Rhodes. Next, we'll have Ms. Schifrin. Joe. We may need to have you up. Sorry, but Ms. Schifrin, you're still muted. So if you could unmute yourself and we'll start over again. All right, Paul. There you go.
Chairman Smith and members of the Judicial Proceedings Committee, good afternoon. My name is Joe Schifrin.
I'm a volunteer leader with Jews United for Justice and a resident of Montgomery County. I'm testifying in favor of JPR 15, repealing Leober, and in opposition to the other bills under consideration this week. Policing in Maryland is a broken legacy of a racist system. It is past time for partial reforms. Since 2015, Maryland police have killed 79 people, 58% of whom were Black. Maryland's population is only 29% Black. Police, when confronted with white and Black people exhibiting the same behavior, will disproportionately arrest Black people. A series of police reforms were enacted following the murder of Freddie Gray Jr. in police custody, but nothing really changed. I appreciate the efforts undertaken by Senator Smith and his colleagues on JPR, but we must give people real control over the officers who are supposed to protect them. The Law Enforcement Officers' Bill of Rights, which gives far more protection to police officers than to other public employees, must be repealed in its entirety. Chiefs of police must have the ability to fire those who abuse the residents they are sworn to serve. Control of the Baltimore City Police Department must be restored to Baltimore City residents. Investigations into police misconduct must be transparent. Currently, the public has no access to police files because the Maryland Public Information Act classifies this data as confidential. There must be a statewide law that strictly limits a police officer's use of force. Too many Black and brown people have been injured or killed by the police. School resource officers must be removed from our schools. When police officers are present, arrests of children increase. Instead, we need to provide counselors, social workers, and other services that support children. More than 60 organizations across the state are in agreement. These are changes we want, and anything less is unacceptable. I respectfully urge you to support JPR 15 and to pass additional strong legislation to truly change policing in Maryland. Thank you.
Thank you very much, Ms. Schifrin, and thank you for your time and your testimony today. Thanks. Next, we'll move on to Mr. Deans, Richard Deans. Can you, Mr. Dean, can you unmute yourself? There you go.
Hello. Yeah.
There you go. We can hear you. Good to go.
My name is Richard Deans. At about 6:30 on June the 18th, I was driving my motorcycle, just leaving my business, which I own on Silver Hill Road, Old Silver Hill Road. I was following behind my neighbor and I slipped on some gravel on my motorcycle and got into a minor fender bender with her. We both moved our vehicles, and then the ambulance came and we exchanged information and all of that. I said I was okay. I was walking back because I was only about 200 yards away from my shop, away from my business. I was walking back when I heard someone like yelling. So I turned around, and then it was two officers approached me. When the officers approached me, one of the officers walked up, the white officer walked up to me and said that I can't leave the scene of an accident. And I explained to him that I've already exchanged information that I didn't leave the scene of an accident. Like everything's over, I'm just walking back to my shop. So then he started to put his hands in his pocket. I noticed that he had like a clip on his pocket. I don't know what he was reaching for or why he was putting his hands in his pocket. And he started to shoulder bump me. And I told him, this was during the coronavirus. I told him to back away from me. And I asked him what he's reaching for. And then he told me, like, let me tell you something, and punched me in my face. And punched me in my face, threw me to the ground, and started slamming my head against a concrete. And by the grace of God, I was on Instagram Live after my motorcycle accident. I was on Instagram Live, so I caught the whole thing on Instagram. So I have the video, and I don't think he realized that he was on Instagram. when he did these things to me. And even afterwards, I just felt terrorized. I just felt terrorized by the police. When he brought me to the hospital, he was still keeping his hand on his gun, just being very aggressive towards me. And like I said, just thankfully I was able to get this on film. And the charging documents, he charged me with assault against a police officer when on the film, and in actuality, he assaulted me.
Thank you, Mr. Deans, for that. And Officer Rawl, sorry about what happened, but I really do appreciate you sharing your story. It'll help us as we move forward. So thank you very much for your testimony today. So next we'll move over to Miss Boardman, Tiana.
Hello, and thank you for allowing me to speak today. So my name is Tiana Boardman. I am a third-year evening student at the University of Baltimore School of Law. I'm also the student chair for the MAJ Civil Rights and Constitutional Law Division and a paralegal at Hansel Law. One of my duties as a paralegal is to compile the settlement statements for our clients. And I have seen more often than not when the costs and fees associated with bringing these cases can be upwards of 30% of that cap, especially in cases where our clients had to seek medical attention. Mr. Greenberg earlier mentioned a client whose fees medical costs alone were over $500,000. And if we have medical experts testifying, that can be in the tens of thousands as well. So what this cap is constructively telling our clients is, yes, your life has value, but only a fraction of a percent. It's not fair to them. Time and time and again, I've seen juries award our clients much more money that our clients will never see because of these caps. It's interesting that a jury of complete strangers see the worth and value and importance in our community members, and law enforcement and sometimes legislators as well do not see that same value. I also speak on behalf of myself today as a Black woman, as a Baltimore City resident, a new Baltimore City resident, and as a person who has friends and family members and who sees clients that look just like me. It's sometimes terrifying seeing law enforcement officers and knowing that they can operate the way they do. And if something were to happen to me, then what happens to my family, who I intend to provide for? I also speak on behalf of women like Breonna Taylor and India Cager, also Black women who were murdered by law enforcement, and their families are left empty. They're left with a hole inside of them. So I see their bright flames. Their flames have been extinguished, but I'm here to reignite those flames and stand for justice with them and people who look like me and members of my community. I am emphatically in support of JPR 11. The proposed changes to the statutory cap will certainly force departments to be more cognizant of the actions of their officers and to show due reverence to the members of their communities. Again, thank you for allowing me to speak today.
Thank you, Ms. Boardman, and thanks for the work you're already doing in law school. So good luck with 3L year and the bar exam. Okay, next we'll move to Ms. Ha, Keisha.
Yes, can you hear me?
We can. Good to go.
As an independent journalist, I respectfully submit that any meaningful discussion of police accountability must include a significant expansion of records access via the Maryland PIA statute. Across the state, a front-page police story could run nearly every day on the use of deadly force, intimidation, planting of evidence, or some other ethically challenged cops being banned from testifying in court if police themselves weren't in charge of disseminating said information. In current draft form, legislation promising increased accountability does little to remove obstacles, namely politicians and actors within the criminal justice system, from keeping journalists from freely spreading light on the systems that perpetuate tenets of white supremacy that continues to be overlooked by our governing bodies. Repeal LEOBR. Why continue to put wolves in charge of counting the number of chickens missing from the chicken coop? JPR2 puts the onus on state prosecutors and law enforcement to collect and maintain complaints for the database. A slightly more progressive stance would give public defenders this responsibility instead. Quiet as it's kept, citizens have complaints about local states' attorneys and judges too. As such, this body shouldn't sleep on increased accountability there either. Empowering the Office of State Prosecutors as the investigatory arm for the most serious of infractions pretends to be a red tape nightmare for any journalist who have ever saw an MPIA request from a state prosecutor. To uphold the Fourth Estate, all citizen complaints as well as civil lawsuits should be accessible to those who identify as press, corporate and independent, via a searchable database at no cost, preferably overseen by independent civilian authority. As for JPR 8, while redacted footage can be made available to the general public, reporters should be permitted to view in a controlled environment raw, unedited body-worn camera data. Furthermore, anyone but law enforcement should be charged with overseeing and regularly authenticating the repository of video captures. In sum, increased police accountability can be achieved quickly and cheaply simply by allowing for expanded media access. Lastly, the whistleblower and duty to intervene legislations, JPR 5 and 7 respectively, relies on a steady stream of good officers to turn the tide of corruption that is so ingrained in policing culture that it would be like trying to save the Titanic from sinking by having the ship's best cooks use turkey basters. With 20 plus years of journalism experience, I can remember when beat cops and sergeants were comfortably speaking with members of the press. In contrast to today's cops' no snitching culture, many refuse to cross the blue line to give comment. In a perfect world, Sean Suter's partner, David Bominka, would have been made available to the press for comments. Free West Baltimore. Just 20 seconds more. Halt a sinking democracy by repealing LEOBR, born of racist fear-mongering, and establish a civilian oversight public safety commission and consider disbanding Baltimore Police Department. Reimagining public safety takes imagination. If there was ever time to make transformative decisions, alter the course of history that finally addresses white supremacy, this is that moment. Return the power to the people. Thank you very much.
Thank you very much, Ms. Hopp. Thank you. Next, we have Ms. Dorsey Walker. You can unmute yourself, Ms. Walker. And there you go. We can hear you.
Good. My name is Linda Dorsey Walker. First, let me share with you that I was honored to put on 4 straight law enforcement conferences that were statewide, attended by 400 police, sheriff, FBI, Homeland Security officers from throughout the state of Maryland and 6 surrounding states. At each one of those conferences, at the end, our Baltimore County State's Attorney, Scott Schillenberger, was invited to be the closing speaker. And at that time, he took the time to advise each of the officers how to avoid getting themselves in trouble, either through testimony or during the arrest process. Now, with that as the background, let me share with you this. While there's been much focus on police reform, I'm seeking reform in the state's attorney's office. Yeah. I come before you to ask that a civilian review board reflective of the population of each jurisdiction be established to review the actions of the state's attorney's offices following all trials involving a law enforcement officer and civilian that results in the death or permanent injury. Currently, there's not a statewide mandate for that level of oversight. The civilian review board, unlike what is being proposed in the investigators, would come in on the back end instead of the front end. So I agree with the state's attorneys that said that. Whether they would be responsible for determining whether due diligence was exercised by the prosecutor in all cases, and to also bring about accountability, especially when state's attorneys have not sought to arrest an officer. Here's the reason I'm seeking the prosecution reform. 8 years ago, the death and trial of Christopher Brown took place. Christopher was an innocent 17-year-old boy killed by an enraged off-duty Baltimore County police officer who was facing a domestic relations court case the following day. In minutes, the angry officer choked a stranger to death because he mistakenly thought Christopher banged on the front door of his house that day. Later, he found out that other boys who admitted that they had done it were responsible. He had killed the wrong person. The medical examiner initially called the death a homicide, but because of the actions of the police and state's attorney's office, instead of a murder trial, what followed was the following. The homicide finding by the medical examiner was changed to manslaughter. Two key witnesses who stood only a few feet away from the killing in their yard on their property were excused by the state's attorney's office from having to testify.
Ms. Walker, I wanted to let you know you're 20 seconds over, so if we could briefly conclude.
I wrote down the time for every one of the last several speakers. You gave them 4 minutes. I expect the same thing.
I did not give them 4 minutes, but if you could please succinctly.
I have the same 4 minutes you gave them.
Please.
Unfortunately,
that's not your decision, but please respectfully.
Why did I know you would make me the exception? I wrote down the times. I can give you the times on every one.
Your time's ticking right now, so please.
Witnesses were not called. The defense and the FOP suggested that the off-limit chokehold was really just a wrestling hold gone wrong. There were not adequate attempts to refute the defense claims that the officer's life was in danger when he chased an innocent boy 3 blocks wearing a brace on his knee. Far too many, and also, let me just say this, the responsible officer was declared not guilty, even of—
Okay, Ms. Walker, I really appreciate it. We'll take the rest on if you've written testimony. I appreciate your time.
I'll give you the times that you gave to all of the previous people, and it was on average 4 minutes.
I'm sure you will. I appreciate it. Thank you very much. Next, we'll have Ms. Landers.
Hello there. My name is Claire Landers. I serve as co-chair of the Baltimore Leadership Council of Jews United for Justice. JUFJ is over 5,000 members strong in Maryland, and we advocate for racial equity and economic justice on the state level and in our local communities. Last year, Baltimore County, where I live, ranked #1 over every other jurisdiction in all of Maryland in officer-involved civilian deaths. In January, Jamal Brown, a 31-year-old county resident, called 911 requesting help. 4 county officers responded to his home and deployed tasers, which induced cardiac arrest. The public has never received any answers to very basic questions around how and why Mr. Brown's call for help ended up in his death by taser. I recently reviewed a cell phone video recorded last year showing a county officer with his knee on the neck of an 8th grade girl restrained on the floor of the school cafeteria in Northwestern Academy because she disobeyed his order to be silent. Did he face any disciplinary action? Again, the public has received no answers to reasonable questions. Just a 5-minute walk from my home, my neighbors in Baltimore City fund the Baltimore Police Department with a $500 million budget every year. Yet neither they nor their own elected city officials have any say over the operations of the deeply troubled BPD. How is that still possible in this day and age? The answer to all of the above, in my view, is that in Maryland, we have a system that permits police to police themselves without any accountability to outsiders, meaning members of the public like me, elected officials like you, or even direct victims of police abuse or the families of victims. JUFJ urges you to take the courageous steps in changing this flawed and imbalanced system by repealing LEOBR, reforming MPIA's privacy protections around police misconduct complaints, removing law enforcement officers from our schools, and restoring control of Baltimore City's police to the people who live there.
Appreciate your testimony. Next, we will move on to Ms. Sege. We can have you unmute yourself. I'm sorry. There you go.
Okay, hi, thank you so much for letting me speak. I'll try to be brief. I'm here on behalf of Women of Color for Equal Justice. We just have a few comments. As you know, it's a very lengthy bill. JPR 8, with regard to body camera footage, it doesn't have specific language with regard to when footage needs to be redacted. It lacks specificity as to when the custodian of record has a valid reason to redact footage. So it looks like that would be a reason to not have information that should be public because it lacks specificity. Also under JPR 8, it says that police do not have to release body cam footage when it would interfere with a current valid and proper law enforcement proceeding. Here, this exception in the bill could swallow the rule, and this becomes a when and how body cam footage will not be released to the public law, as opposed to the title of that law that says when body footage should be released to the public. JPR 9, the feedback that we have with that is that every department, we should have language in JPR 9 that states that every department shall purchase body camera batteries with a shelf life of no less than 12 hours. When one camera goes off, that battery needs to be replaced. And if that doesn't happen, then there is a willful failure to activate that camera, and the police officer should be held liable. Much like we have a black box at the time of a flight that has all the information of what happened, we need to have reliable information available to the public without excuses for not providing it. And once again, I believe that there's kind of a laundry list of excuses without measures to fix those technical problems that may happen, and there are possibly pretty easy fixes, like having longer shelf life batteries, for example. Then we also have JPR 10, and at this point we don't have specific language, except that we will provide that when we've had more time to review the bill. We wanted to keep the prosecution local. However, we need to have community lawyers investigating wrongdoing, that if the community is not satisfied with the lack of prosecution of certain cases, we need to have some type of community oversight with that. And we can share some ideas of how that might happen in more specificity when we've had more time to review JPR 10. We also have some feedback with regard to the low limits that are being set for cases that have predominantly affected Black and people of color. And we should not have low caps, and having low caps sends a clear and incorrect message that Black lives don't matter. We agree with the plaintiffs.
So I interject again, just keeping the time, being fair with everyone.
All right, and then the last piece of feedback is from JPR. I think I've gone through most of the feedback. Okay, I'm sorry, that there needs to be language with regard to JPR 12 that states when a police officer should be tested for drugs and alcohol. It should not only include major bodily injury or death, but it should also include sexual assault, dishonesty, perjury, false statements, false reports, falsification of concealing evidence directly relating to reporting, charging, investigation, discrimination, or bias. So the police should have to submit themselves to drug and alcohol testing in those cases, not only with major bodily injury or death.
Thank you, Ms. Saget. Thank you. I know that it's hard to keep within the time because I'm trying to, be fair with everyone. So I appreciate your efforts.
Thank you.
Okay, Ms. Pope.
I am here. Can you hear me?
Yes, we can.
Okay, thanks. Thank you, Chairman Smith and members of this committee. The public rightly holds its law enforcement officers to a standard of high ethics. Yet police have been empowered in carrying out methods that have a philosophy of self-preservation at all costs, putting them at odds with people of color, especially Black people. I'm Amity Pope, a doctoral candidate, president of Our Prince George's, and co-founder of PG Changemakers Coalition. When police interact with us, we all have the right to be safe, be free from discrimination, be equally protected before the law, and survive the encounter. Body cameras that are robust in implementation, storage, and usage are definitely something victims of police assault and killings believe is needed. Now, I witnessed an assault committed by a lieutenant of District 7 in Prince George's County about a month ago when he shoved a peaceful protester that responded to his question. A body camera would have been helpful in that situation, as the cost of investigating this assault would be lessened. Yet this bill is written communicates to the people that somehow that assault would nicely fit into one of the exceptions bulleted in this bill, and there'd be no way to make that footage inadmissible in court or any legal proceeding for that matter. Additionally, as read, this bill seems to create the notion that the public will be harmed by recordings. Well, the people find this very disturbing because it is the people that's recording the wrongdoings of officers on their personal cell phones and uploading them to social media to go viral. If it weren't for this form of civil disobedience, body cameras probably wouldn't be a talking point today. So in closing, this bill reads to ask the state of Maryland to invest hundreds of thousands of dollars to invest in equipment that ultimately can be totally redacted from the public and set the public back even further in seeking the very much needed justice. We need to feel like it's okay to be alive. Body-worn cameras can help provide transparency and accountability in policing, but this can only be the case if the public has access to the footage. So access to this footage is controlled by the Maryland Public Information Act. I'm Amity Pope, and on behalf of the many voices I represent when I speak, this JPR 8 as read sets our state backwards in providing the community with the slight opportunity to show transparency of interactions with Maryland police officers. And as a result, we oppose it as written. Thank you.
Thank you, Ms. Pope. It was good to hear from you again. And thank you for your testimony. We are, I think, at the end, we have one last, just a 2-minute video testimony from Ms. Kimberly Jones that I think Sandy will play right now. And at that, with this will be the end of our hearings today. So Sandy, whenever you're ready. We can't hear it. If we could turn the volume up a little bit.
Thank you very much.
I can't hear you.
Okay, Sandy, if we could pause it just because we're having an audio problem. We can't hear anything from Ms. Jones. If we could adjust the volume. On the bottom left there.
Yeah, I turned it up. It's all the way up.
I just have to mail it out to them.
Okay, so it looks like we're going to pause it here. It looks like it's on maximum volume, but what we'll do is we'll make it. We'll try to make this publicly available with a different version. It looks like there's a corruption in the file. So with that, that will unceremoniously conclude our hearings for the day. Thank you all very much. Thank you for all the participants, and thank you for the witnesses and members of the public that participated today. We'll see you tomorrow at 1 p.m. Have a good one.